Yes. Yes.
Yes.
From that side. Yes. Yes. Anyone mention? Order 14 is
My lord, this is the application of
application. Yes.
Order
Order 41 and application. Application, please hand over. Order 41 and application without mentioning, you can hand over. The other matter is that this is application.
There is something.
Please stop here. Last step.
No.
My lord,
We'll come to you. Yes.
there is something I need to mention, my lord.
Yes.
That's the application for modification, my lord. The lordship has directed me to file in the meantime and mention so that the can appear on the next date of hearing, which is 27th of January.
You've given any indication?
Yes, my lord. I have mentioned it in my 199. Can হচ্ছে 5 ওই দীপক মুখার্জি সুতপা মুখার্জি
Yes.
May I have your lordship's kind leave to mention, your lordship, this is I'm appearing for the appellant, and this is an appeal arising out of the order passed by the learned civil court. This honorable court was pleased to pass an order directing the defendant not to disturb the possession of the appellant, but the defendant, the respondent, your lordship, acted in willful disobedience of the order, cut my electricity line, and restrained me from doing my regular business. I have a small shop inside Oberoi Grand Hotel. My only request is, your lordship, hearing this particular application and the appeal for final disposal.
You have filed a contempt application.
No, your lordship, I have not. I want, your lordship, my instruction is to get the application for stay and the appeal heard.
Application for stay we can include, but appeal hearing we are not doing right.
Grateful, your lordship.
Yes, yes.
Grateful.
Your lordship leave and file this first appeal without the copy of the decree.
Why?
The decree is not drawn. City Civil Court matter, judgment passed on 17 December. I have obtained the certified copy of the judgment.
No, file it, it will be defective. File the decree.
Without leave, I cannot file, my lord.
Judge, you have the judgment?
Yeah, I have the judgment.
Yes, yes, you can file. Judgment now, order 20 contemplates that, order 41 and order 20 contemplate that you can only file with the judge.
Previously also I have filed, but with the leave of the court.
No, leave is not required. You can file it.
Attach the application for the certified copy also.
Very well, we are granting you leave. No leave is required. Judgment, with judgment you can file now, but that will be defective under the under our rules. Anyway, leave is granted. Yes, sir.
My lord, this is the case on 2nd December 2024. Your lordship was pleased to pass that if the paper books are ready, you can file the petition for hearing. And I have mentioned in 18th 12th.
We are giving leave in every matter when the matter is ready for hearing to get. But right now we are too hard pressed because these are all the appeal files. Our officers won't be able to see you. Already they are not being able to see you.
Fixed it on February 8th.
No, not right now. Sorry, sir, we are not including. Hearing we are not including right now. We have to dispose of some of these matters. No.
My lord, I am suffering from 2003.
Understood, but no.
But it has been.
No, sir, no. Sorry.
We are monthly, my lord.
Yes.
May I permit
No.
to mention the matter for admission of first appeal?
Yes. Admission first appeal is not required to be admitted.
Lordship, can is pending. Can one
Application,
of
yes.
Can 1 of 2000 of
Yes, call on the list.
Item number 1 for judgment.
Accordingly, FAT 47 of 2018 is dismissed on contest, thereby affirming the judgment and decree dated October 26, 2017, passed by learned judge, 6th bench, City Civil Court at Calcutta, entitled suit number 3500 of 2007, whereby the plaintiff appellant suit for specific offence was dismissed. No less to cost a formal decree be done. Sorry. Couldn't convince ourselves. Yes, brief. Yes, Mr. Chaudhary, only on that.
Brief. If, before Mr. Chaudhary, just on the scope of the word dispute, I may show your lordship one judgment. Even though, my lord, this is an alternative to the argument that even if two Roman 18.
Be very precise, Mr. Sen. Yes.
Just, my lord, kindly have a look at one paragraph of this.
Give the citation for Mr. Chaudhary.
Yes. 2005-12 HCC 738. Kindly see paragraph 11. Just on the scope of dispute, nothing else. Paragraph 11, kindly come to placetum age. Definition uses the word dispute. The dictionary meaning of the word dispute is to contend any argument, argue for or against something asserted or maintained, Black's Law Dictionary will mean conflict or controversy, specifically one that has given rise to a particular lawsuit. Then, my lord, claim asserted by one party and denied by the other.
Yes.
Claim be false. Then, my lord, dispute means a controversy having positive and negative aspects. So, what I want to say, my lord, commercial dispute arising out of agreement. So that dispute may cover everything, including existence, validity, everything.
Good.
That's a positive and a negative. Other than that, my lord, the other two clauses, my lord, the first clause, transaction,
Yes.
and export and import of goods and services.
Right. Yes, Mr. Chaudhary. On this and on 2C, 21C, I and II.
Yes. Right. I just, my lord, first, my lord, on Commercial Codes Act.
Yes, yes.
My lord, kindly see, my lord, 2CI first. I'm told, my lord, that came up.
Yes.
Ordinary transactions of merchants, bankers, financiers, such as those relating to mercantile documents, including enforcement interpretation of such documents. Two things are, my lord, very important. This provision has been, my lord, interpreted to mean A,
Yes.
that there should be a contract, and B, my lord, it should be a contract in writing. Otherwise, there's no scope of, my lord, any commercial dispute. My lord, can I hand up
Yes.
quickly, my lord? This is, I had a copy though. My lord, kindly, my lord, I'll straight away take your lordship to, my lord, paragraph 7. Reverting core issue, the eventuality enshrined in clause 1 to section 21C of the Act postulates a dispute arising out of ordinary transaction of financier relating to mercantile documents, including enforcement. Said clause can be segregated in three parts. Firstly, the dispute must arise out of ordinary transaction of financier. Secondly, such ordinary transaction must relate to a mercantile document. And thirdly, enforceability and interpretation of such document is involved. Then, please, my lord, come to paragraph 9. Stroud's Judicial Dictionary defines commercial action to mean and include any cause arising out of ordinary transaction of merchants and traders, and without prejudice to the generosity of the following or any cause, etc. Then, my lord, it thus engulfed within itself any action or undertaking object to making profit, etc., etc. Various judgments of Delhi High Court, Bombay High Court, Madras High Court, as well as Calcutta High Court to ascertain the meaning of a mercantile document. My lord, later on, next page, after 10 lines, it is no doubt true that every nature of monetary transaction cannot come. Monetary transaction, ordinary course of business. And then, my lord, paragraph 12, towards last 10 lines, last 8 lines, my lord, as indicated above, there is no condition laid down in the said definition commercial dispute that mercantile document must be executed at the beginning or before the transaction having affected. Rather, the document defined in section 21F of the Act includes any matter expressed or described upon any substance by means of letters, etc., etc. We therefore find no difficulty in considering that mercantile document instrument by any other means coming within the ambit of the definition of a document executed by a merchant in the ordinary course of business. Now, my lord, if your lordship looks at the Delhi High Court judgment, which is, my lord, 2019 SCC Online Delhi 9954. My lord, I am being very quick, my lord. I'm not wasting time on the other paragraphs. My lord.
Yes. Which paragraph should you see?
29, my lord, straight away.
Yes.
That suit must be on a mercantile document. This is submission. Counsel for the on being asked to show under such and such present claim constitutes a commercial dispute, draws attention to clause 1 of section 21C of the Commercial Codes Act. which provides for ordinary transaction of merchants, bankers, financiers, and traders, such as those relating to mercantile document, including enforcement and interpretation of such document, to constitute commercial dispute. Now, plaintiff has to be on a mercantile document for its enforcement or interpretation. However, all suits for recovery of money cannot fall under clause 1 of section. Suit is not based on any transaction relating to mercantile document. It has to be on a mercantile document. Otherwise, it's not possible. So, my lord, there are other judgments also, which I'm not, my lord, citing. Now, if your lordship sees the section once more, my lord, commercial dispute means a dispute arising out of ordinary transaction of merchants, bankers, financiers, and traders, such as those relating to mercantile documents, including enforcement and interpretation. My lord, judgments are, my lord, ad idem of all the three courts, my lord, this Honorable Court, Delhi High Court, Bombay High Court. Suit must, my lord, arise out of a transaction which is within this ambit, and it must be on a document. There must be a document, and it must be for enforcement or interpretation of that document. My suit is not on enforcement, interpretation, or arising out of a document. Rather, it is to say that there is no such contract, there is no such document.
And what about 2?
2, my lord,
Yes.
export or import of merchandise or services. This is now, if your lordship sees, my lord, the contract. My lord, kindly come to, my lord, page 35, which is the first. I'll not quickly take your lordship through all the documents. This is not, my lord, an export-import contract. The sale of goods contract. This, as Mr. Sen, my lord, correctly said, if at all is to come under, my lord, 18. This is an agreement for sale of goods.
It's immaterial whether they import or not, or you import or not.
This is not a document. This is not.
The transaction does not pertain to export-import.
No.
It's only of sale of goods.
It's sale of goods. So,
Whether
my
the
lord,
goods are imported or exported, that's immaterial. That's not the subject matter of the transaction.
no, this is, my lord.
Hmm.
If my lord, I accept, my lord, that if there was an agreement, it would be a commercial suit because of 18.
Hmm.
Now, when the plinth of my submission on this is, A is dispute. My lord, can mean both ways. Arising out of an agreement for sale of goods. My lord, if there is any other dispute which, my lord, arises out of an agreement for sale of goods, but a dispute as to whether the agreement itself exists, that would, my lord, be a commercial suit. If I say agreement, these are the terms, this is how it's to be enforced, it should be rescinded, etc., etc., then that, my lord, becomes a commercial suit. But here my case is, there is no agreement at all. My lord, this is like, my lord, the competence principle in arbitration, section 16. Section 16, my lord, is not there.
You are thinking of arbitration also in this context. Yes. In similar light as you were saying.
Yes. So, my lord, if it is, it's that way. Question of a very existence can't be decided in a commercial suit. There's no, my lord, similar provision as section 16 of Arbitration Act.
But if there is no section 11, Mr. Chaudhary, if there's a reference to arbitration, at what stage does the arbitral tribunal has to decide that question also?
My lord,
Forget section 11. If there's
Yes.
a direct reference,
if this was a section 11 matter,
11 then different. 11 court had to consider.
16.
If there is no section 11, if there's a reference and the arbitrator has to decide then.
Yes.
So, but
But-
that is to be decided by the
But that jurisdiction of the arbitrator and jurisdiction of civil court is not equal.
different.
That jurisdiction of arbitrator is because of the competence principle which is engrafted.
And
in
one
the
other
section.
argument has been raised by Mr. Shen, which is apparently very attractive. that suppose you relied on the document. He took a point, or the plaintiff relies on a document, a commercial agreement. The defendant takes a point, it does not exist. Then that question had to be decided. But then also it would be a commercial dispute.
Yes.
So what is your answer to that? I mean, in any event, you cannot avoid that. Then would the court go out of the commercial court?
Plaint case decides the
So therefore, the frame of the suit is material.
plaint.
Frame of the suit means the plaint.
But if today I make a suit that there's no contract, it's not a suit on a contract.
But as Mr. Shane cited a judgment, a dispute is when there is a basically like an issue.
Yes.
When there is a pleading, there is a controversy.
Yes.
Now, therefore, it's not only the plaint case which is to be looked into.
The written statement case cannot decide what is the suit for.
The commercial courts have determination.
Yes.
The jurisdiction of commercial courts is jurisdiction to try all suits and applications relating to commercial dispute of a specified value.
And what is a commercial dispute? Milord, this has to be read, Milord.
Has to be read in 2-1.
Commercial dispute means a dispute arising out of a contract agreement for sale of goods. Milord, the dispute, which is the assertion and denial, has to arise out of a contract. So my plaint has to say that the disputes which are subject matter of suit arise out of the contract. My plaint determines the nature of the suit, not the defense. Lord, when I say in the plaint that there is no contract, it is not a dispute arising out of a contract. Plaint decides it. Defense does not. Conversely, my lord, if I had said yes, there is an agreement, and he had said that there is no agreement, that would be a commercial suit.
And what one other point has been taken by Mr. Shin, that is, you have also challenged the debit notes. Independently, you have sought an injunction on that also, a declaration also.
Yes.
Debit notes themselves constitute a commercial transaction.
No. Milord, debit notes cannot, Milord, constitute a commercial.
That pertains to a commercial transaction.
Firstly, Milord, yesterday's submissions on, Milord,
irrespective of the contracts, which you say don't exist.
Yes.
You have also challenged the debit notes independently.
Yes.
So the debit notes, those constitute a commercial transaction.
Debit notes, Milord, do not constitute an agreement for sale of goods.
But comes within CI.
No. Milord, this is relating to an agreement for sale of goods. Milord,
CI, to one CI says ordinary transactions of traders also, such as those relating to mercantile document. Is it not a mercantile document? And are they not traders?
That it must relate to an agreement.
No.
It must.
I does not say so. I says those relating to mercantile documents.
Milord,
not agreements.
No, Milord, any commercial document has to relate to an agreement.
Need not be.
Otherwise, Milord, there can't be a commercial transaction.
That's a far-fetched and tertiary interpretation of this provision. Provision is very clear, because that's why Mr. Chaudhuri then all sections, all subsections would relate back to 8. It's not so. Legislature consciously put I and 18 differently. So 18 refers to agreements relating to those transactions, and I says ordinary transactions relating to mercantile documents. So mercantile documents is not restricted to agreements. No. If it was intended to, then it would be subsumed by 18.
No, Milord, here, Milord, may I differ, Milord, in one place?
Yes.
Milord, for there to be a commercial transaction, there has to be an agreement. Otherwise, there cannot be a commercial transaction. But your lordship is right that a mercantile document can be beyond the agreement, can be evidence of the agreement.
Can be only a component of the
This is what Justice Tandon also held in the division bench judgment. Delhi view and Bombay view is more drastic. It says that there has to be an agreement in writing. But Justice Tandon's view is that no.
Any document, letters, etc.
Any document which bears evidence to the agreement.
But those are also in writing.
Yes,
or
but
electronic.
It has to be in writing. It has to be in
Debit
writing.
note is in writing.
Debit note is in writing. But is debit note, my lord, I ask myself the question, is debit note, my lord, evidence of an agreement? Otherwise, my lord, kindly look at a situation like this.
Irrespective of that, you are challenging the debit, you are seeking a declaration and an injunction regarding the debit notes also,
Yes,
which is B and C probably.
yes.
Therefore, if that's, forget about the agreement. This is not about the agreement at all. You are challenging the debit notes also. There are reliefs sought in the suit against debit notes, which are documents relating to mercantile documents relating to transactions of traders.
No, but I'll just indicate. The debit note, kindly see what the debit note says now. Whether on the debit note, I can, my lord, the suit will become a commercial suit. It just says that PAN number such and such, nature of document, rate difference empty, rate difference. And that in their books, this is the amount which is payable. This is not evidence of a contract. So when this is not evidence of a contract, this is, my lord, a document much later which says that rupees such and such is payable. But that does not per se from the document relate to a commercial transaction. There has to be, my lord, the foundation of a commercial suit has to be an existing contract admitted by the plaintiff. Otherwise, there cannot be a commercial suit. Please look at a situation like this. I understand what is in your lordship's mind, that when you are asking for cancellation of a document, which is a mercantile document, in that case, why not a commercial suit? My answer is, for there to be a commercial suit, A, there must be a contract. And B, that contract must be the plaint case. Because without the plaint case being a contract, when the plaint case is converse, that there is no contract, then the jurisdiction of commercial court can never be attracted. When my attack is that there is no contract, I cannot possibly not file a commercial suit, because the commercial suit is only possible to be filed for disputes arising out of a contract, either for sale of goods or for anything else. So a document produced unilaterally by them, of which I am asking for cancellation, because there is no contract, can never be a commercial suit. Got thrown off the main tangent, my lord, while submitting. But now, my lord, looking back, the fulcrum of my submission, yes, it can be called a mercantile document if there was a contract. But my plaint has to admit a contract. Nomenclature of suit is decided by the plaint. When the plaint is that there is no commercial contract, and I'm asking for a declaration that there is no contract, it cannot conceivably, my lord, be a commercial suit. It's the antithesis to a commercial suit. My lord, 2(1)(c) will only arise in each and every case if there is a contract. Without a contract, there cannot be 2(1)(c). If your lordship, bill of exchange is a contract. Check is, my lord, a negotiable instrument. You can sue on it. My lord, without a contract, my lord, it's fundamental that without a contract, there cannot be, my lord, a commercial suit. And when my plaint is an antithesis to a contract, there's no question of it being a commercial suit. My lord, plaint has to be seen to be true and correct for the purpose of deciding what is the nature of my suit. It cannot be, my lord. Now, my lord, two further facts, my lord. Look, please think of it. It's a very interesting question. And Mr. Sen is right when he says that what would have happened if it had been the other way around. If your plaintiff had said it's a contract, and I had said that there's no contract. If the defendant's case is it's no contract, then, my lord, it's a commercial suit. If he sues me for money on a contract, it will be a commercial suit. But if I sue him saying that there is no contract, it can never be a commercial suit. This is, my lord, the situation. And In no case under 2(1)(a) can there be a commercial suit if the plaintiff says there is no contract. No case. Please see, my lord, every case, it's all agreement. And dispute arising out of an agreement. My lord, dispute, this is important, my lord. The dispute arising out of I to, my lord, XXII. And each of it is, my lord, a contract of a different kind.
You had cited Justice Datta's judgment, this unreported Asma Latif. You
Now, my lord, just two things. On another point, this is something, my lord, I checked up. And my learned friend will, my lord, correct me if I have missed it. Issue, my lord, of Specific Relief Act, Section 41, is not there in the Order 39, Rule 4. It is not there in the written objection. Now, this is an interpretation of an order of injunction. That he says, I feel that I am bound, I am restrained from filing a counterclaim or filing a suit. The injunction is not a direct injunction. Now, please see the specific relief. Your lordship has seen. I don't want to blur. So, my lord, I'll just make my points very quickly. A, my lord, this point is not there in either. So, my lord, before the learned court below, my learned friend's client did not feel that this injunction restrained them from, my lord, filing a counterclaim or proceeding elsewhere. That is important because it's not a direct order of injunction. It's an interpretation. And they didn't feel that way. For the first time, this ground is taken in the stay petition and in memorandum of appeal. Stay petition, paragraph 29, he says, I can't go and file a suit. I can't proceed with my claims in arbitration, etc., everywhere. And, my lord, in the memorandum, this point is, my lord, also taken. Now, the important, my lord, two quick judgments, my lord, I want to show your lordship. One, my lord, is ILR 1991, Karnataka, page 254.
This is on what point?
Specific Relief Act. My lord, paragraph 23 at page 294. Okay, no, ILR print out, yes. 84, my lord, kindly, my lord, come to the page.
Yes.
Section 41 of the Specific Relief Act is a restrictive provision. It imposes restriction or limitation to the jurisdiction of civil court. Therefore, it has to be interpreted very strictly and not liberally. In interpreting Section 41, care should be taken to ensure scope of section is not unduly expanded or widened, as it will result in curtailment of or limiting jurisdiction of a civil court. Section 41B applies to a case where the relief sought is only to restrain any person from instituting or proceeding any proceeding in court, not subordinate to that from which the injunction is sought. It will not apply to a suit where relief of declaration and other consequential reliefs, including possession, are sought. If the relief sought for in the suit lies within jurisdiction of civil court, it is open to it to pass appropriate interim order in aid of final relief which is sought in the suit. In passing of such a decree or interim order results in disabling the defendant in a suit from instituting or prosecuting any proceeding in a court not subordinate, it cannot be held its hit. Civil court has jurisdiction to entertain the suit. It follows it has jurisdiction for interim orders. Now, my lord, here I have a relief of cancellation of these notes. So all I've said is don't give effect. If I'm not saying that it stops them from filing a suit, I admit, my lord, that they can file a suit despite this order of injunction. But if they imagine so that they are stopped, my lord, in that case, this interim order is in aid of my relief of declaration.
Yes.
There is another judgment of this honorable court, and this is my last judgment. Okay. Sorry. Yeah, I'm this is an alternative submission.
Yes.
Lord, AIR 1925, Calcutta 233. Lord, I request your lordships, my lord, to see the last paragraph, which is paragraph 10 of the print, my lord. It is well settled. Temporary injunctions are governed not by the Act, by the provisions of Civil Procedure Code. Order 39, Rule 1, temporary injunction may be granted by subordinate court, etc., etc. So far as perpetual injunctions are concerned, they are, my lord, covered by specific relief act. So, my lord, it is, my lord, the tests are
I don't
less.
agree with this view. Palpably wrong here. Palpably wrong. 36, section 36, 37 of specific relief acts. Palpably wrong view. Can't agree. However old it may be,
I found
from
it in
whoever
the
it
IR manual.
from whoever it may be. Section 36, 37 are very clear.
Let
Let us come to those sections. 37 provides the basis of granting temporary injunctions. Order 39, Rule 1 and 2 is the procedure. And even Order 39, Rule 1 and 2 is backed up by a section in the 74 or 76, something like that.
No, this is not, I'm not for once saying that a court can pass an injunction when, my lord.
Let
it's
us pass an injunction against a proceeding in the Supreme Court and let us see the reaction.
I wouldn't. my lord.
Unacceptable. Section 37 is
No,
very
no,
clear. Temporary injunctions are such that
No,
this
my
is
lord,
the
it's
source of
it's in a different light.
no different light. It's specifically held here under that a temporary injunction may be granted under Order 39, Rule 1 and 2, and perpetual injunction is under the specific relief act. Not acceptable.
100 years.
Wrong law.
100 years ago.
100 years of incorrectness remains
No,
incorrectness.
but
100 years, even if it's solitude, well, it becomes very loud when you look at it in retrospect.
no, these
100 years of error remains an error, Mr. Chaudhary.
correct.
Whoever may be the judge.
That is
And after 100 years, the same thing will be said about us. We hope so. Because then we'll be knowing that society is really moving.
law evolves.
It was wrong then also. Because then
That's why I understand why your lordship
is repeating that whoever it may be.
Yes.
Whoever it may be.
true, my lord. Not that I say, but I am, regardless of the outcome of the matter, my lord, I am harping, my lord. I shouldn't be saying this, but please consider, my lord, when your lordships think about it,
Definitely. We'll
that one thing, my lord, that plaint decides nature of suit. And if plaint doesn't say that there's a contract, there can never be a commercial suit. That's a very fundamental issue which I raise. And I should have stuck to only this in my attempt to deal with Mr. Sen's argument.
Just 2 minutes.
Grateful, my lord.
Paragraph 3 and
Milord.
4 of the plaint.
With your lordship's
Yes,
permission,
yes,
may I again run away?
আমার অবাক
Yes,
হচ্ছে,
yes.
আমার already হয়ে গেল।
Yes.
Only 2 minutes, my lord. Paragraph 3 and 4 of the plaint.
We have marked 3 and 4 right now.
Import. Why I am showing you, lordship, my lord? This is
Not
coming
marked
under
for that.
import.
Show us that portion.
Yes, my lord. Paragraph
I have
3,
not marked for
however,
import.
from inquiries made
Plaintiff
from
was aware that defendant number 1 was importing crude oil, palm oil into India. No,
those circumstances.
no, Mr. Sen, there's a distinction. Defendant number 1 was importing crude palm oil. But this agreement is not for import export.
Yes, yes. Well,
You are importing, but they have entered into a sale agreement. They are not importing. This agreement, the debit note or the contracts
is
are not for
my
the
claim is for the import,
maybe, but
but the subject matter has
this is not with a foreign trader. You have not entered into an agreement with a foreign trader to import.
May not
Import
be.
export. This agreement is not for import export.
Otherwise, the defendant number 1 was importing
Yes.
crude oil into India. In those circumstances, contact the defendant number 2 and whether defendant number would sell such product to the plaintiff. So
If the defendant number 1's contract, the contract of defendant number 1 with his exporter, if that was under consideration, then it would be an import-export agreement. But he imports. Import is done. You want to buy from him that imported product.
But kindly see, this is export or import. He is buying.
Mr. Shen, if I go to a shop and buy an imported good, that would not be an import-export transaction.
He comes into the claim because of that import. He comes with me.
That's again you are going to the tertiary logic.
I just show you, lordship. I do not want to.
But we'll consider this also.
C1, my lord. Again, I come back to C1.
C1 is also there.
C1 and rely upon Justice Tandon's judgment, the observation.
Any document. Any document.
And what is
letter.
the nature of the document? Well, just paragraph 12.
Yes.
Paragraph 12, just last 5-6 lines, as indicated above.
Yes.
There is no condition laid down in the said definition commercial dispute. The market document must be executed at the beginning or before the transaction having affected. Rather, the document defined in 2(1)(f) of the Act includes any matter expressed or described upon any substance by means of letters, figures, or marks intended to be used or which may be used for the purpose of recording the matter. So the debit note is a reflection of a transaction which he is avoiding in the plaint. This is, my lord, with regard to 1. With regard to C2, paragraph 3 and 4, substance of the plaint is a deal sought to be entered into for imported material. And he entered into the transaction, wanted to enter into the transaction because he knew that I was an importer. So it is not that I am only trading in the imported material, I am an importer. I import. That is also his case in paragraph 3. However, from inquiries made by the plaintiff has come to learn defendant number 1 is an importer. So I import and sell. I do not depend on X for import.
Yes, we will pass out. The present appeal has been yes. The present appeal has been preferred.
Only, my lord, subject to correction if your lordship otherwise also protects my right of recovery. Anyway,
the present appeal arises at the behest of a defendant in a suit for declaration and consequential reliefs pushed up by the impugned order, the learned trial judge granted temporary injunction restraining the defendants from giving any effect or further effect or acting in terms of or in furtherance of 2 debit notes dated December 26, 2020, December 26, 2022, bearing number caps DBOOT/57 and dated December 26, 2022, bearing number DBOOT/58 in any manner whatsoever. First of next para, learned senior counsel appearing for the appellant argues that the impugned order is vitiated due to lack of jurisdiction of the civil court to pass such an order. First up, it is argued that the suit as framed is covered by a commercial dispute as contemplated in section 2 within bracket 1 within bracket small c, comma, clauses small 18 XV triple I bracket closed, comma, small I and small II of the Commercial Courts Act 2015. First up, next para. In addition, comma, it is submitted that the impugned order grants an injunction which violates the spirit of section 41 within bracket small b of the Specific Relief Act 1963. First up, next para. Learned senior counsel further argues on merits that in view of 2 consignment notes having admittedly been entered into between the parties, comma, the same formed the plinth of the contract between the parties, which was subsequently given effect to by virtue of the debit notes in question. Full stop. Although the plaintiff, although the defendant stroke appellant also relies on 2 purported contracts, comma, it is submitted that the said contracts were entered into in furtherance of the original consignment notes and that the consignment notes themselves formed a concluded contract, comma, in view of consensus ad idem having been arrived at between the parties at that juncture itself. Full stop. Next para. Learned senior counsel for the appellant cites such and such reported at 2005 12 SCC 738, where the Supreme Court observed inter alia that The dictionary meaning of the word double inverted dispute is colon to contend any argument semicolon argue for or against something asserted or maintained. Full stop. A conflict or controversy which comes within the purview of the term double inverted dispute, comma, it was held, comma, means a controversy having both positive and negative aspects. Full stop. Next para. It postulates the assertion of a claim by one party and its denial by the other. Full stop. Thus, comma, it is contended that although the plaintiff stroke respondents sought a declaration that there is no existence of the two contracts dated August 16, 2022 and September 29, 2022, which were later entered into between the parties pursuant to the consignment note, comma, the defense of the present appellant is that the said agreements do exist, full stop, as such, comma, such agreements pertaining to sale of goods which comes within the purview of specified value as contemplated in the Commercial Courts Act, comma, the dispute is a commercial dispute, full stop, since the debit notes, comma, cumulatively, comma, put the valuation of the transaction to around rupees 2.5 crore, comma, it is not the city civil court, comma, sitting in jurisdiction as an ordinary civil court, comma, but the commercial division of this court which has jurisdiction. Full stop. Next para. Learned senior counsel appearing for the appellant next cites an unreported judgment of the Supreme Court in the matter of Asma Latif, ASMA, LATEEF, and another versus Shabbir Ahmad and others, where the Supreme Court observed that the question of jurisdiction would assume importance even at the stage when a court considers the question of grant of interim relief, full stop, where interim relief is claimed in a suit before a civil court and the party to be affected by grant of such relief, comma, or any other party to the suit, comma, raises a point of maintainability thereof, or that it is barred by law, and also contends on the basis that interim relief should not be granted, comma, grant of relief in whatever form, comma, if at all, comma, ought to be preceded by formation and recording of at least a prima facie satisfaction that the suit is maintainable or that it is not barred by law. Full stop. Next para. Thus, comma, even while granting injunction, comma, the learned trial judge, comma, it is argued, comma, ought to have considered the question of jurisdiction. Full stop. Next para. While controverting the arguments of the appellant, comma, learned senior counsel appearing for the plaintiff respondent argues that the suit, comma, as framed, comma, has to be gathered from the plaint and not from any further pleadings in defense. Full stop. If the plaint is looked at comprehensively, comma, it is argued, comma, it would clearly indicate that the very existence of the two commercial agreements which are relied on by the defendants has been questioned in the suit. Full stop. It is argued that if the very existence of the agreements are questioned, comma, the suit does not come within the purview of a commercial dispute as envisaged in section 2 within bracket 1 within brackets small c within bracket Roman 18 of the Commercial Courts Act, comma, since the said provision only contemplates disputes, তারপর italic say arising out of, এটা italic say, arising out of agreements for sale of goods, full stop, where the very existence of the agreement is in question and has been challenged, comma, there arises no question of there being any dispute arising out of such agreement. Full stop. Next para. Insofar as clause small I of subclause small I of clause small c of section 2 within bracket 1 is concerned, comma, it is argued that ordinary transactions of merchants, comma, traders, etc., such as those relating to mercantile documents, are a prerequisite of the dispute coming within the said provision. First of it is argued that in the present case, comma, even the debit notes in question arise out of the purported contracts, comma, the very existence of which has been challenged. Full stop. Next para. Since the existence of mercantile documents is a sine qua non for a dispute to come within section 2 within bracket 1 within bracket small c within bracket small I of the Commercial Courts Act, comma, it is contended that there being no agreement in existence, comma, the said provision also does not come into play. Full stop. Next para. In support of such contention, comma, learned senior counsel cites such and such reported at 2022 SCC Online Cal 3010, where a division bench of this court held inter alia that there is no condition laid down in the definition of commercial dispute that the mercantile document must be executed at the beginning or before the transaction having affected. Rather, the document defined in section 2 within bracket 1 within bracket small f of the Act includes any matter expressed or described upon any substance by means of letters, comma, figures or marks or electronic means, comma, etc., for the purpose of recording the matter. Thus, comma, it is reiterated that a document is necessary for the purpose of the dispute coming within section 2 within bracket 1 within bracket small c within bracket small I. Next para. Insofar as subclause small ii is concerned, comma, it is argued that the present transaction does not pertain to export or import of merchandise, whereas the defendant number 1 might have imported the goods, comma, the present suit relates to the absence of any agreement between the plaintiff and the defendants, comma, which is not in the nature of import or export of such goods. Next para. Learned senior counsel appearing for the respondent, plaintiff stroke respondent, next cites such and such reported at 2019 SCC Online Dell 9954, where a learned single judge of the Delhi High Court observed that all suits for recovery of monies cannot fall under clause small I of section 2 within bracket 1 within bracket small c of the Commercial Courts Act. Suffice it to state that the suit is not based on any transaction relating to mercantile documents. Next para. Learned senior counsel next relies on a division bench judgment of the Karnataka High Court reported at ILR 1991 KAR 254 নামটা দেখে করে নিও। In the said judgment, comma, the division bench of the Karnataka High Court had held that section 41 within bracket small b of the Specific Relief Act applies to a case wherein the relief sought is only to restrain any person from instituting or prosecuting any proceeding in a court not subordinate to that from which the injunction is sought. It will not apply to a suit wherein a relief of declaration and other consequential reliefs, including possession, etc., are sought. If the relief sought for in the suit lies within the jurisdiction of the civil court, comma, it is open to it to pass an appropriate interim order to aid the final relief which is sought in the suit. If passing of such a decree or interim order results in disabling the defendant in the suit from instituting or prosecuting any proceeding in a court not subordinate to the court in which the suit is filed, comma, it cannot be held that it is hit by section 41 within bracket small b of the Specific Relief Act. Next para. Lastly, comma, learned senior counsel for the respondent cites judgment of a learned single judge of this court reported at AIR 1925 Cal 233. It was held in the said judgment that it is well settled that temporary injunctions are governed not by the Act within bracket Specific Relief Act, but by the provisions of the Code of Civil Procedure, Order 39, Rule 1, and a temporary injunction may be granted by a subordinate court against a party even in respect of proceedings in a superior court. Full stop. So far as perpetual injunctions are concerned, they are regulated by the Act, and an injunction cannot be issued by a court to stay proceedings in a suit not subordinate to that from which the injunction is issued. Full stop. Next para. Upon hearing learned counsel for the parties, we arrive at the following conclusion. So next para. Insofar as the argument of the appellant that the injunction granted by the impugned order hits section 41 within bracket small b of the Specific Relief Act, we are unable to agree with such proposition. Full stop. The injunction has been passed in respect of enforcement of two purported debit notes. Full stop. The said documents, veracity has been challenged in the suit, and as such, the relief sought in and as such, the temporary injunction granted is in aid of the final relief. Full stop. Per se, a restraint order in respect of the debit notes does not translate directly to an order restraining the defendants from instituting or prosecuting any proceeding in a court not subordinate to that from which the injunction is sought. Full stop. As held by the division bench of the Karnataka High Court, if incidentally such grant of temporary injunction has the secondary effect of restraining a person from relying on such document in a suit, the said fact ipso facto does not tantamount to the injunction order being violative of section 41 within bracket small b of the Specific Relief Act. Full stop. However, with utmost respect to the high erudition of the learned single judge, in the matter of Ram Shodon Biswas Supra, we are unable to agree with such proposition. Full stop. The relief of temporary injunction, as held in the said judgment, does not flow from Order 39 Rules 1 and 2 of the Code of Civil Procedure at all. Full stop. The origin and source of grant of injunction lies in equity. Full stop. After crystallization of such equitable principles by codification in the Indian context, sections 36 and 37 of the Specific Relief Act clearly provide for such grant. Full stop. Section 36 stipulates that preventive relief is granted at the discretion of the court by injunction, italics temporary, or perpetual. Full stop. Again, section 37 deals with temporary and perpetual injunctions. Full stop. Subsection 1 refers to temporary injunctions, whereas subsection 2 of section 37 speaks about perpetual injunction. Full stop. Thus, the source of power to grant injunction, if at all, flows from section 37 of the Specific Relief Act first. Full stop. Order 39 Rules 1 and 2 provides merely the procedure governing such grants and the circumstances in which such grant is permitted. Full stop. Next para. As such, comma, the distinction between a temporary injunction being governed by the code and a perpetual injunction by the specific relief act is an artificial distinction not sanctioned by the scheme of things in the Indian jurisprudence. Full stop. Next para. Be that as it may, comma, in view of our earlier observations, comma, we are of the opinion that the injunction granted in the present case is in aid of the final relief sought in the suit and is not in contravention of section 41 within bracket small b of the specific relief act per se. Full stop. Next para. The next question which arises is as to jurisdiction. Full stop. Next para. A very relevant question has been argued as to whether the suit is covered by section 2 within bracket 1 within bracket small c within bracket small 18 Roman 18 of the Commercial Courts Act 2015. Full stop. Next para. It would be diametrically contrary to the scheme and object and reasons of the enactment of the Commercial Courts Act in the event a restrictive interpretation is lent to the provisions thereof. Full stop. In the statement of objects and reasons of the 2015 Act, comma, it is specifically provided that the proposal to provide for speedy disposal of high value commercial disputes was the trigger for such enactment. Full stop. Again, comma, the statement of objects and reasons of the Amendment Act of 2018 to the said Act provides that the global economic environment has since become increasingly competitive, and to attract business at international level, comma, India needs to further improve its ranking in the World Bank within single inverted doing business report single inverted close, which, comma, inter alia, comma, considers the dispute resolution environment in the country as one of the parameters for doing business. Full stop. In such context, comma, the statement of objects and reasons further records that the tremendous economic development has ushered in enormous commercial activities in the country, and early resolution of commercial disputes has been given a positive thrust in the said objects and reasons. Full stop. In such context, comma, if we as Indian courts, comma, give an extremely restrictive view to the same, comma, it would be contrary to the scheme of the legislative intent. Full stop. Next para. Seen from such perspective, comma, section 2 within bracket 1 within bracket small c speaks about disputes within double inverted arising out of double inverted close, and clause Roman 18 stipulates agreements for sale of goods or provisions of services. Full stop. In such context, comma, a dispute arising out of an agreement for sale also encompasses a dispute as to the veracity, comma, authenticity, or, comma, stretched a bit further, comma, the very existence of such agreement as well. Full stop. Next para. As rightly argued by learned senior counsel for the appellant, comma, it may very well be that plaintiff relies on a particular commercial agreement, whereas the defense taken in the written statement is that such agreement does not exist. Full stop. In such case, comma, it would be absurd to say that although at the inception the commercial court had jurisdiction, comma, it loses the same in view of the defense taken. Full stop. Next para. Learned senior counsel for the respondent has argued that the question as to jurisdiction under the Commercial Courts Act has to be decided on the frame of the suit, for which the court has to look only to the plaintiff pleadings. Full stop. However, comma, the issue of jurisdiction, comma, which hits at the maintainability of an injunction application and the prima facie case aspect of the matter, comma, is wider than the limited scope of a demurrer application under Order 7, Rule 11 of the Code of Civil Procedure. Full stop. Whereas in the latter, comma, the court only has to look at the plaint pleadings, comma, while while deciding an issue of jurisdiction, comma, the dispute double inverted মধ্যে has to be considered as a whole. Full stop. A dispute, comma, by its very definition, comma, can only arise, comma, akin to an issue as contemplated in the Code of Civil Procedure, comma, when one party asserts something and the other denies the same. Full stop. Thus, comma, if we consider the broader perspective of the expression commercial dispute double inverted মধ্যে, comma, the entire dispute, comma, including the contentions of the rival parties, has to be taken into consideration to ascertain the nature of the dispute. Full stop. Thus, comma, in the present case, although the plaintiff asserts that there was no existence of two contracts, comma, the defendant very much relies on such documents, comma, which is evident from the plaint itself and furnishes a cause of action for the suit. Full stop. Unless the defendants relied on such contracts, comma, and made a claim thereon, comma, there would not arise any occasion for the rights of the plaintiff being infringed and the suit being filed itself. Full stop. Next para. Thus, comma, in the present context, comma, since the agreement for sale of goods pertaining to the specified value has been challenged in the suit, comma, the dispute definitely comes within the purview of section 2 within bracket 1 within brackets small c within brackets small 18. Full stop. Furthermore, comma, subclause small I of clause c of section 2 within bracket 1 is also attracted. Full stop. In the division bench judgment of this court in the matter of Venkatesh Vincom cited by the respondent, comma, the court rightly held that a document for the purpose of a commercial dispute includes any matter expressed or described upon any substance by means of letters, comma, figures or marks or even electronic means intended to be used for the purpose of recording the matter. Full stop. Next para. Although the context of the said judgment was an interpretation of double inverted document as defined in section 2 within brackets 1 within brackets small f, comma, the said concept can be imported to the present case as well. Full stop. In the present suit, comma, the plaintiff has not only challenged the existence of two particular contracts, but has also sought specific declaration challenging two debit notes as well as perpetual injunction in respect of such debit notes. Full stop. The debit notes, comma, cumulatively, comma, indicate a figure of around rupees 2.5 crore, which comes within the specified value and as such, comma, brings the suit within the purview of a commercial dispute as envisaged in section 2 within bracket 1 within bracket small c within bracket small I, comma, being related to an ordinary transaction relating to mercantile documents. Full stop. Next para. Also, comma, even if the dispute falls within the purview of ordinary transactions, dehors a particular document, comma, subclause small I is applicable. Full stop. The said provision stipulates that disputes arising out of ordinary transactions of merchants, comma, traders, comma, etc. তারপর ডাবল ইনভার্টের মধ্যে such as those relating to mercantile documents to come within the purview of the act. Full stop. The use of the term double inverted such as clearly shows that existence of documents is not a sine qua non, but the stress lies on transactions. Full stop. For example, comma, even if there was a verbal transaction in due course of the regular customs of the particular trade, comma, without anything boiling down to written agreements or documents, comma, it would come within the purview of section 2 within bracket 1 within bracket small c within bracket small I, comma, since the said provision relates to ordinary transactions of traders, semicolon, the use of the expression such as double inverted মধ্যে makes the said provision inclusive and not exhaustive. Full stop. Next para. Thus, comma, mercantile documents are used as an example by way of illustration, and the main provision relates to ordinary transactions, comma, with or without written documents. Full stop. Next para. Again, comma, coming to subclause small, however, comma, coming to subclause small ii of clause small c of section 2(1), comma, we are unable to agree that the present transaction relates to export or import. Full stop. In paragraph number 4, comma, the plaintiff has stated that the defendant number 1 was importing crude palm oil. Full stop. However, comma, the transactions in question pertain to agreements or non-existent agreements between the plaintiff and defendant, both of whom are domestic, both of whom, which is a domestic transaction. Full stop. Although incidentally the defendant number 1 might have imported the crude palm oil, comma, the present transaction is not pertaining to such import but is a domestic transaction. Full stop. Next para. As such, comma, subclause small ii is not attracted. Full stop. Next para. However, comma, the very nature of the plaint pleadings indicate that the suit relates to a commercial dispute coming within the purview of section 2 within bracket 1 within bracket small c, comma, subclauses small I and small 18. Full stop. Next para. Even a perusal of the plaint shows that the entire gamut of the transactions is a commercial transaction revolving around the debit notes which have been challenged. Full stop. In paragraph 3 of the plaint, comma, the plaintiff alleges that it was not aware of the precise nature of business of defendant number 1 and never had any form of business relation. However, from inquiries made, the plaintiff learned that the defendant number 1 is an importer of different commodities. Full stop. More importantly, comma, in paragraph 4, comma, it is alleged that the plaintiff, double inverted, in the usual course of business, double inverted close, had a business requirement of crude palm oil of a designated entity. The plaintiff was aware that the defendant number 1 was importing such crude palm oil and contacted defendant number 2. Full stop. Upon such approaches being made, comma, emails were exchanged and confirmation notes were executed agreeing to ship crude palm oil in July 2022 and August 2022. Full stop. Next para. The plaint case is that subsequently such transaction failed to go through and as such the contract never fructified. Full stop. Next para. Such paragraphs themselves show amply that the entire purview of the plaint revolves around commercial transactions, and as such, comma, there cannot be any manner of doubt that the suit comes within the purview of a commercial dispute as envisaged in section 2 of the Commercial Courts Act. Full stop. Next para. In view of the specified value as extracted from the debit notes which are under challenge being to the tune of around rupees 2.5 crore, comma, even on a prima facie premise, comma, it cannot but be said that the commercial division of this court has jurisdiction to take up the suit, to entertain and decide the suit under Section 7 of the Commercial Courts Act 2015. Full stop. Next para. Since maintainability of a suit hits at the prima facie case, comma, which is a sine qua non for grant of injunction, comma, we are of the opinion that even without going into the merits of the contentions of the parties, comma, it is palpable that the learned trial judge lacked jurisdiction as a civil court, comma, to entertain the suit and to pass the order of injunction. Full stop. Hence, comma, the impugned order of injunction ought to be set aside on such count alone. Full stop. Accordingly, FMAT 259 of 2024 is allowed on contest, comma, thereby setting aside the impugned order bearing order number 20 dated June 6, 2024, passed by the 5th bench City Civil Court at Calcutta in title suit number 85 of 2023. Full stop. The connected application bearing can 2 of 2024 is stands dismissed consequentially. Full stop. No address to cost.
Lord, subject to correction, Lord, can 2 was my learned
Stay
head's
application.
application.
Oh, it's disposed of. Or a disposal.
It's
Thank you for pointing. It নিন।
Item number 3, Lordship, I am for the appellant. I
Yes.
led by Mr. Subodh Banerjee, learned advocate, Lordship. On the last occasion, your Lordship has directed to deposit the special messenger cost. I have within a week, but Lordship, I have deposited the cost beyond time, Lordship. I am praying for extending the time.
There was no other defect. Deficit code for rupees 80. Memo of appeal required to be corrected.
No, that is not.
Anyway, the learned advocate appearing for the appellant seeks condonation of the delay in belated deposit of special messenger costs. Full stop. Such delay is condoned and the delayed deposit of special messenger costs is accepted. Full stop. The records be called for accordingly. Full stop. Leave is granted to the learned. The learned advocate on record for the appellant is directed to cure the 2 defects pointed out by the learned registrar administration.
That has been, Lordship, that 2 defects has been sought out. Only 1 defect is the Lordship.
80 rupees deficit code fee has been paid.
That has been paid.
That is what we are asking you. You are not being able to say. Pay করেছে মেমোতে আছে আর এটা কারেকশনটা করে দিয়েছে মেমোতে একটা কারেকশন করার কথা ছিল ঠিক আছে আর পরের সেন্টেন্সটা কেটে দাও দ্য ডিপার্টমেন্ট কি বললাম দ্যাট না লাস্টে কি সেন্টেন্সটা বললাম দ্যাট রেকর্ডস বিকজ বাই স্পেশাল মেসেঞ্জার পোস্ট থ্যাংক ইউ নেক্সট appeal to memo to correct the rules.
The word number I'm praying for release.
In view of the appearance for one of the parties of a relative of one of us within bracket Bhattacharya J, comma, the matter is released from our list on personal ground with liberty to seek an assignment before a different bench.
This is my application, my lord.
Madam, for that. If you have kindly look into the last order.
For deposit of deficit court fees, my lord.
You have cured the defects.
Yes. There must be some report of the camp.
In compliance with the order, deficit code fee has been filed, revised report has been due. Yes, deficit code fee has been.
There are.
And condonation application is there.
No, your last occasion, please to.
Oh, that way, wrong report.
Wrong.
We have also cured.
Yes.
Well, so what is your application?
My lord, 5 applications pending.
Five?
Five
Can 5 is
number of
last
application.
application is my application. This is vacating application. Now the rest 1, 2, 3, 4 is his application.
What are rest 1, 2, 3, 4?
Yeah. 2 are substitution application. Application number 1 for injunction. Application number 2 and 3 for substitution. Application number 4 for permission to reconstruct the residential house. And 5 is for lordship.
So first which has to be allowed?
Substitution application. That's why I'm trying to say my.
You are right. Substitution, because otherwise all orders will be in the name of dead person.
Yes, Malad.
2 substitution applications.
Yes.
2 people died.
But yes, Malad. One is
Most of the
appellant
people-
number 1. Appellant number 3.
What are the cans?
Can number 7030 of 2018.
No, now renumbered probably.
Renumbered
Can 3 is 1
Yes.
and the other is can 2.
Yes, Malad. Others can.
Let us find out can 2 and 3.
Can 1 is old 4586 and can 2 is old can 703.
Oh, let us forget the old. Let us look at the. Okay, can 3 we have found. Can 2 we'll have to find out. আপনি একটা কাজ করুন।
May I hand it over to you a copy because there is
No, no, no,
time.
don't. এটা এই সুতোগুলো খুলে নিয়ে না ক্যান When 030 is now 2.
Yes.
Substitution of who is he? Appellant number 3. This is within time.
Within time.
We are allowing this.
Just within.
Acha, what about 3? Can 3 is also within time? No.
Can 3 is out of time.
Suppose let us allow can 2. প্রথমটা হবে can 2.
Cannot injunction.
Can injunction will come later. Injunction and vacating will take up together of this. Can 2 of 2018.
18.
Can 2 of 20 2 also of 2018. Original law was of 2018.
No, 2 was.
Acha, can 2 of 2018 within bracket. Old number can 7030 of 2018 is an application for substitution of the heirs and legal representatives of the deceased original appellant number 3. Full stop. The heirs have been mentioned where?
At page, at paragraph, my lord,
3. Right. Next para. Since the application is in time and otherwise in form, comma, can 2 of 2018 is allowed, comma, thereby directing the heirs and legal representatives of the deceased appellant number 3, comma, as described in paragraph number 3 of the application, comma, to be substituted in place and stead of the said deceased appellant number 3, full stop. Necessary consequential amendments to the memorandum of appeal shall be carried out by the office within a fortnight from date. Acha. Next is can 3. What is the delay and what is the reason for that?
the respondent number 7 died. We came to know after serving notice. It was returned back with an endorsement. Died.
What is the approximate delay?
A delay of almost a year. Maybe.
Acha, yes, they came to know later. Very well. Can 3 of 2022 is an application for substitution of the heirs and legal representatives of the deceased respondent number 7 Hanif Sheikh, comma, after setting aside amendment on condonation of delay. Full stop. The case made out in the application for the delay is that the appellants came to know of such demise later from the they made submission in court.
No, it was a
Communication.
back with an endorsement.
From an endorsement on a returned envelope of service that the respondent number 7 had met his demise. Full stop. Next para. We find sufficient cause for the delay in making the application. Full stop. Accordingly, can 3 of 2022 is allowed, comma, thereby directing the heirs and legal representatives of the deceased respondent number 7, as mentioned in paragraph number 3 of the present application, to be substituted in place and stead of the deceased after setting aside abatement on condonation of delay in making the application. Full stop. The necessary consequential amendments to the memorandum in that regard shall also be carried out by the office within a fortnight from date. Now,
Can 1 is for
1 and 5 are we are taking up together because 1
can 4 হচ্ছে তোমার
can 4 is for permission to do what?
For reconstruct the residential house. Just damage. But it will
That is objected to, my lord. This is partition is not yet better.
There can be objection to that. So let us take up the injunction first.
Can 1 and can
So injunction, what injunction? The appeal is against what?
apply suit for partition. Dismiss on the ground that all the co-sharers not made party.
What is your defense to that?
No, but I have in my plaint and in my impugned order, you will find that we have challenged the ownership of particular person. We have said that they are not the co-sharer of the
Request to be heard. So why should we?
Interim order was passed by this honorable court.
When
at the time of-
2016 interim order was passed, I enjoyed for not.
No, my lord, if you are
More
for
than
diet,
10 years, my lord.
I can file the
No, those directions will give you in any event that the special messenger cost. So we are disposing. You should have been more alert. If you should have filed this application earlier. Anyway, we are disposing of the vacating and the injunction. We are maintaining the injunction till disposal of the appeal. But we'll direct them to put in special messenger cost and
Introduce, my lord. My lord, in there is an order on 29 November 2022 by Honorable Justice Tapobodo Chakraborty and Parthasarathi Chatterjee
yes.
to the application being can 5 or 2 is an application for vacating the interim order dated 4th October 2016. Mr. Ghosh, the learned advocate appearing for the appellant's plaintiffs, would be at liberty to file an affidavit in opposition to the said application within 2 weeks from the date. Reply thereto, if any, be filed within a week thereafter. Please the matter 3. That is
What is the case made out in the vacating for vacating?
Since 2016, enjoyed this.
That by itself is not a ground for vacating.
Without expeditious taking steps.
That does not come within order 13 and rule 4. Yes, substantial hardship maybe, but we are passing directions. If you want to prepare the paper books, we can direct you to.
Only expeditious hearing, Mala.
Expediting direct, we are directing, but will you prepare the paper books and bear the cost for that?
Appellant.
Appellant. We will direct the appellant. Can 1 of 20? What is the
Can
number?
1 of 2016.
Can 1 of 2016 within bracket old number can 4586 of 2016 is an application for injunction, whereas can 5 of 2022 is an application for vacating the ad interim order of injunction passed in connection therewith. Full stop. Next para. We find that the present appeal has been preferred against the dismissal of a suit for partition filed by the plaintiff's appellants. Full stop. Whereas the learned trial judge observed that the suit was bad for non-joinder of all the co-owners, comma, the plaintiffs raise an issue that the left out parties are not owners of the property at all. Full stop. Since such question has to be decided both on facts and law in the appeal, comma, we are of the opinion that there is sufficient prima facie case for hearing the appeal on merits. Full stop. Accordingly, can 1 of 2016 along with can 5 of 2022 are disposed of by directing both parties to maintain status quo in respect of possession, nature, and character. Possession as well as nature and character of the suit property till disposal of the appeal. Full stop. Next para. The appellant shall. Now, you are appearing for which of the respondents? All the respondents? Very well. In view of the appearance of all the respondents to their learned advocate, comma, service of notice of appeal on the respondents is dispensed with. Full stop. The Trial court records shall be brought by special messenger at the cost of the appellants, to be deposited positively within 1 week from date. Full stop. Next para. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Necessary repairing works may be done in the.
Now let us come to 4. That
Both the parties.
construct and reconstruct.
Well, it is a mud house.
Mud house, yes.
It was damaged. We paid for before the Panchayat authority. Panchayat granted the permission.
How do you want to reconstruct? Now a pakka structure? Nature character. We have just now granted injunction.
Yes, that is my application.
No.
No, we have to dismiss this, but we'll grant you leave to repair it without changing nature and character to its original condition.
Both the parties then.
You have not asked for it.
I have to repair on that.
You also have a mud hut. You have to apply for that. You have to apply for that. Can 4 of 2022 has been preferred by the appellants seeking permission to construct and or reconstruct a residential pakka house instead of the presently existing mud built house over a portion of the suit property. Full stop. Next para.
Then
How-
at the time of reconstruction, there may be a collision.
However, such prayer is opposed by the respondents. Full stop. Next para. Since in view of the status quo order passed earlier today on the application of the appellants themselves, and as we are of the opinion that construction of a pakka structure at this juncture over a particular portion of the joint property may give additional rights to one of the parties detrimental to the other's interests, we are not inclined to grant such permission to make reconstruction. Full stop. However, leave is granted to the petitioner to carry out necessary repair works to the mud structure standing over the suit property and used by the appellants without changing the original nature and character of the same. Full stop.
Without encroaching. Without encroachment.
Full stop. It is made clear that such repair work shall be done at the own cost of the appellants without claiming any special equity for the same. Full stop. The appellants, while making such repair work, shall not encroach on any other portion of the property than over which the mud construction originally stood. No, that's too costly. Fine. So all applications are now put in a special messenger. We'll come back. Yes, we'll come back in 5 minutes for the next one.
Service করি সবগুলো জিনিস
এই যে,
ঠিক আছে
হ্যাঁ গো।
আমাদের মেমো আপিল করে সার্ভিস করি
My
Yes, please.
confusion, my lord.
Yes. Other side is not appearing.
My lord, service were made for all the respondents, but only respondent number 2 has received. Rest has been returned.
No, you have to file a proper affidavit of service.
No, we are filing today the affidavit of
What is the endorsement on those envelopes?
first. For the first time, respondent number 1 envelope is having refused.
Refused is that is respondent number 1.
Respondent number 1.
Acha, refused is good service. All right, next.
Second time when it was sent to him,
Huh.
the postal remark is cannot be located.
First time refused.
First time refused.
Number 2, respondent number 2.
Insufficient address, but second time he has received.
2 has received second
2
time.
has received. 3, 4 it shows absent. First time shows insufficient address. Second time shows he absent.
Acha,
5 is deceased.
gone. So then you have to take out a substitution. This is the difficulty in civil matters, pending for so long, and we are not being able to take up. And by the time you reach the end of the matter, there will be more substitution applications than other applications. So, but it then takes steps, Mr. Learned counsel for the appellant fairly submits that from the endorsement in the envelope sent to the respondent number 5 you said 5, it transpires that the said respondent has met her demise in the meantime. So accordingly, the appellants shall take steps for substitution of the heirs and legal representatives of the said deceased. First off, let the matter go out of the list for the present, with liberty to the appellants to mention the application for substitution along with the other applications as and when filed.
A revisional application is pending in this Honorable High Court at Calcutta.
Revision against what? Interlocutory order.
Okay.
And this appeal is against what?
Final order.
Of what suit?
There was a partition suit which against the preliminary order, a revisional application was filed. Against the final order, we have come before your.
But against preliminary degree also first appeal lies.
Yes, but the learned advocate only can file a revisional application there, which is pending, and they are appearing there.
So you can try serving on them. Let us see what.
Yes, Lord. If your lordship.
But first file the substitution, then we can direct. Please remind us on the next occasion when the substitution is filed. Mention it. We'll include it along with the other applications. We'll pass orders maybe to serve on that. Just remind us, Mr. Bhatt.
Removal of the defect. This is the
What are the
removal of the defect? Dismiss for dismiss.
Oh, you did not remove the defect. That's why dismissed.
Yes, 42 days delay, section 5.
What are the defects? Which you did not. Let us see the defects. Defects মেমোটা copy of the judgment of the suit illegible. You were only directed to file a typed copy of the judgment of the trial court.
I will within a.
No, you have to do that. This will be conditional on that. First, you prepare that copy, bring it to us. We will keep it on record and allow your application. Deficit code fee আছে? Fees are also there. এখানে তো নেই কোথায় additional ও কি কি দেখুন না রেস্টোর করলে allowing this application conditional on your curing the defects deficit code fee and that typed copy
Copy of the judgment.
file it in the department within a week. Can 2 of 2023 is an application for recalling the order dated May 12, 2023 passed by a coordinate bench whereby the appeal was dismissed for failure on the part of the appellants to remove the defects. First up, we find from the records that deficit court fees of rupees 258 were not deposited by the appellants, comma, nor did the learned advocate for the appellants furnish a typed copy, a legible typed copy of the judgment of the trial court, comma, which is the certified copy of which is illegible at places. So next para, on the submission made by learned counsel for the appellants that the appellants shall positively cure the defects within a week from date, comma, can 2 of 2023 is allowed, comma, thereby recalling the order dated May 12, 2023 and restoring the second appeal to its original file and number, comma, subject, comma, however, to the appellants curing both the defects as indicated above within January 31, 2025. We are giving you more than 2025. First up, next para, the office shall furnish a further report regarding such removal of defects. First up, the matter shall next be listed under the heading to be mentioned on February 10, 2025 for passing further orders.
Section 5 is also dismissed. 42 days delay.
No, first remove the defects then.
So, section 5 in connection with this recalling application.
Oh, say that. Where is this section 5 application? What is the number?
Number can 3.
What is the reason for the delay?
But intimation given to the client, he did not.
যেটা পুরোটা বললাম না তার আগে পুরোটার আগে একটা প্যারাগ্রাফ অ্যাড করে দিন।
Paragraph 6.
Upon perusal of the averments made in Can 3 of 2023, comma, we are satisfied of the sufficiency of the reasons for the delay in preferring Can 2 of 2023. So accordingly, Can 3 of 2023 is allowed, condoning the delay in filing Can 2 of 2023. তারপর যেটা বলুন এটা ফেব্রুয়ারি 10th টু বি মেনশন অফিস রিপোর্ট দিলে ওটা ট্যাগ এটা অফিসকে পাঠিয়ে দেবেন ওটা ডিফেক্ট
I am the appellant petition for the respondent numbers 1 and 2, your Lord.
Yes.
I'm filing my affidavit in opposition. It is 6 days beyond time. I'm praying for condonation of the defendant.
Whatever the reply.
Today I am serving it today, your Lordship.
Affidavit in opposition filed today be kept on record. Full stop. Since a copy of the same is being handed over to the learned advocate for the appellant only today, comma, the time for filing reply is extended for a week. Full stop. Let the application be listed next on January 30, 2025 under the same heading.
Grateful.
Item number 9.
Lordship, I'm appearing on behalf of the respondent husband. Lordship, as per your previous direction, we have to submit the evidence on asset and the opposition. But
the direction was given long back.
Yes, your Lordship, but unfortunately some incident was happened to my father. That is, my petitioner, my respondent's father was a cerebral attack, and that's why there is some problem to come before me, and that's why it was not ready. So it is my humble request before Lordship, kindly make it on the month of February, first week. Before that, I will ready out everything. I have the documents, all medical documents.
No, why February? We are on 21st only. Do it within January 28th.
Your Lordship, he was not in that position because his father needed support. It is my humble submission.
His father is still under that condition.
Exactly, Your Lordship, all the medical documents.
But that will continue for some time.
Absolutely, Your Lordship. That's why
we cannot wait indefinitely. So we are giving you till for.
Okay, Your Lordship, kindly give me a 2 weeks time at least.
Mediation. Some interim leave immediately.
Yes. What alimony have you asked for?
Was 1 lakh 20.
What is his income?
1 lakh 20 income. More than. I've given 1 lakh 20 income.
Now, do you have a child?
No, Your Lordship.
No issue. What does he do? What does your client do
Right now is no job, no service.
after the
no-
alimony application being filed?
Not at all.
No job, cerebral attack, all this happen after.
No, Lordship, this cerebral attack was happened in the last month 29. That's why I need to file my affidavit of asset, Lordship.
Key business.
What was your last income? What was your job?
Key business.
I am making a
Key businesses.
What sort of business?
Lordship, as per the instruction I have
Pay a lump sum amount in the meantime. We cannot grant you indefinite time. Pay a lump sum amount of
Lordship,
50,000.
For the very last time, for the very last incident.
Very
you
last
can
time we are
get-
granting
if
you
he
time,
not
but you
come, then you can
pay them 50,000 within these 2 weeks. Learned counsel for the respondent husband seeks a fortnight's time for filing affidavit in opposition and affidavit of asset by the respondent on the ground that the same could not be prepared in the meantime due to the father of the respondent having suffered a cerebral attack. First of next para. In view of such prayer and the ground mentioned by the respondent, we extend the time for filing affidavit in opposition as well as affidavit of asset of the respondent husband till February 5, 2025. Full stop. Reply, if any, shall be filed by February 12, 2025. The application shall be listed next on February 17, 2025. Full stop. In the meantime, the respondent husband shall pay an ad hoc amount of rupees 50,000 within February 5, 2025 to the appellant wife, subject to the outcome of the alimony application. We'll adjust this amount ultimately, but pay 50,000 by 5th.
Can do is for stay application. While disposing the case stay application, mediation was not passed. It was pending.
So already a lot.
The application, no interim order has been passed.
Mediation order.
Mediation has failed.
It was already over, Your Lordship, on the very last occasion.
Therefore, can two is pending.
Cantu will decide. You are enjoying an interim order. There is no interim order.
Your Lordship, my respondent is already remarried. So what is the?
You have already remarried.
Yes, sir, Your Lordship. It was already held up in our last
Earlier
occasion
occasion it was-
before you.
You had disclosed in your opposition. You had filed an opposition to the section.
Never.
So where will direct you to file your opposition? Disclose there. It can 1 year holo to order. Alimony was
Only four.
alimony was 4, and this is stay. আচ্ছা এটা can 4 এ হলো এবার can 2 তে the respondent shall file affidavit in opposition to can 2 of 2024. Which year? Of 2023 within a fortnight from date. Full stop. Reply if any shall be filed within a week thereafter. Full stop. Can 2 of 2023 shall be listed along with the alimony application on the returnable date. Use your opposition to that, reply to that. The two applications will appear together.
I'm deposited the social passenger cost.
That will consider later. Let us dispose of these applications first.
Record of direct.
Yes.
Helpful.
Next. You for the appellant? Yes, Mr. Haldar, what is the delay?
Delay is of 143 days.
What is the ground? Delay in filing the appeal?
Yes, madam.
What is the appeal against?
Appeal is against the ex parte decree of divorce. In connection with 125 proceedings, my lord, in course of hearing, they produced it, the certified copy of the ex
Decree.
parte decree.
So you learned from there. You learned from there for the first time.
Yes, for the first time, on 28th March 2023.
And when did you file the appeal?
I applied for certified copy and I filed the appeal in May.
Yes, you are condoning the delay.
May I? My lord, I have already filed a opposition to the condonation of delay application.
You have?
Thereafter, yes, my lord, thereafter.
No, we don't find any opposition here.
Yes, ma'am.
Opposition কোথায়? দেখুন তো opposition কোথায়?
Your Lordship, my lord, last occasion while this matter was taken up, your Lordship wanted, after hearing my learned friend, that his core argument is that
Take the mic a bit closer.
my lord, the person who had, the person, the lady who had been represented before the learned court below was not his client. So the Wakalatnama, which was submitted before the learned court below, that is of one Sujata Ghosh instead of Sujata Kaur. Sorry, my lord, I'm taking the Supriya Ghosh instead of Supriya Kaur.
Sujata,
Kaur.
Sujata.
Yes. Now, after hearing that argument, your lordship wanted to see the Wakalatnama. Last occasion, he filed it by way of a supplementary affidavit, the certified copy of the Wakalatnama, and your lordship granted me liberty to file opposition to such supplementary affidavit, which is here.
And this is the one reply.
Reply has been served upon me today outside the court. My lord.
Today.
Yes. My lord, if your lordship is dealing with the section 5 application only, then I will not get into the merit with regard to the Wakalatnama and all. My lord, in the section 5 application, there is no mention of the day from which the delay is being computed.
According to you, what will be the delay?
My lord,
143 days we are lenient on.
Right.
So let us allow the section 5.
Right.
And then immediately after that, the supplementary affidavit was in respect of that stay application.
Stay application.
We'll come to that. Let us just allow this application. Immediately after that, we'll take up stay.
Not stay application, that is not in connection with section 5 application.
No.
No. Supplementary affidavit was
Can number 1. Can 2.
Can 1 is the section 5.
Yes.
Can 2 is the stay. Affidavit in opposition, reply all in respect of 2. All in handed over the opposition and the reply.
Today is the opposition with regard to the supplementary affidavit and reply has
Oh,
been
this is in respect of Can 1.
Can 1. The condonation of debate.
Malad, it is in connection with we filed application, supplementary affidavit in connection with 1.
So let us find out the supplementary affidavit now.
In connection with can number 1. Because 2 has not been, unless and until the section 5 is allowed.
আপনি একটুখানি আমাকে বার করে দেবেন
Affidavit in connection with can 2.
Supplementary affidavit এখানে দেখুন তো একটু
It is wrongly mentioned.
supplementary
It should be 1.
It is mentioned in the cost item.
I will just check.
Yes, should be 1, Malad.
Position to the supplementary affidavit.
Yes, my lord. Today I have submitted. And it was served upon them long back.
Today,
I also filed reply.
Just now I have.
today opposition, but you don't say that it's against the supplementary affidavit. You have just mentioned can 2. In affidavit opposition, it's nowhere mentioned it's in respect of the supplementary affidavit. You merely mention can 2.
Yes, ma'am.
And the reply is also says that.
But the
Supplementary affidavit is
wrongly filed in connection with can 2.
there is no supplementary affidavit. This is affidavit in opposition and reply. Supplementary affidavit was filed in connection with can 2 undoubtedly. Very well, we'll take this opposition and reply to be regarding the supplementary affidavit. But all those are in respect of can 2.
No, can 1.
No. The supplementary affidavit, the caption says to.
Yes.
Your reply says to.
That is the wrongly
Then
because
your reply also says to. Supplementary affidavit also says to. Supplementary affidavit is your supplementary affidavit. Your supplementary affidavit. That says can to.
Because
Everything which follows says can to.
that has been wrongly printed. It should be one because section 5 is to be allowed first. Thereafter,
Section 5 we can allow and then, but
section can 1 is relates to section 5.
Section 5.
But section can 2 relates to application for
Stay.
judgment and declare. Can
Yes.
3
Injunction.
restraining them from remarrying.
That is
Understood.
served upon us today. Can 3.
So what do you propose? I mean, shall we look into the supplementary affidavits regarding can 1?
Can 1
My lord, if I
Can
my
1.
lord, your lordship condones the delay.
How is it German to can 1?
Yes.
Yes, my lord.
So it
If
has to
judgment
be
in 1, my lord.
connection with can 2.
No, let us hear him.
Yes.
My name is kindly have a look at the cost title, my lord. Sujata Kaur Wilko. This is my name, my lord, and the suit was filed against this person. Kindly have a look at the certified copy. I have filed supplementary affidavit, wherein it appears that one Supriya Ghosh.
Contested degree, but you say you are not served.
I am not certain. Third party, one Supriya Ghosh. This is the signature of Supriya Ghosh. She appeared in the said suit. She appeared for 2 or 3 occasions. Thereafter, due to non-taking of any stage, suit was posted in the ex parte board and suit decreed ex parte.
But how is it this relevant for can 1?
Correct, Miller. That's why.
Can 1 is only the reason because you knew for the first time.
This is
Even if you are the Supriya Ghosh aspect was not there, then also you knew for the first time because when the suit was decreed, you were not present. It's either Supriya or you. So in any event, you can take this defense that for the section 5. Yes.
In the appeal,
This is a very relevant factor in the appeal and the stay. So we'll treat this as supplementary affidavit to can 2. He is asking for can 1 to be allowed and you are opposing. Can 1 ta shudhu age dichi. Upon perusing the application, the affidavit in opposition and the affidavit in reply, we are convinced of the sufficiency of the cause shown by the appellant for the delay in preferring the appeal. Full stop. The decree was an ex parte decree, and the appellant pleads that only upon coming to know of the said decree in a proceeding between the parties under section 125 of the Code of Criminal Procedure, the appellant became aware of the ex parte decree and took steps, causing the delay. Full stop. Upon hearing learned counsel, can 1 of 2023 is allowed on contest, thereby condoning the delay in preferring FAT 150 of 2024. So the appeal is deemed to stand registered and admitted. Now move can 2. Can 2, this will be German for can 2 and can 3 also. Stay we don't generally grant because it's a sort of judgment in rem, but injunction restraining. Have you remarried in the meantime?
No. And I have.
So what about this? What about your argument on this? This will be but Mr. Haldar, if you want to rely on this, these are a part of the record. Then this is a part of the record. So we can hear this in appeal. This aspect of the matter at the stay or injunction stage, there is no use because in any event, if the appeal is admitted, which is automatic, so we'll grant injunction and we'll record these supplementary affidavit and your opposition. What is your opposition to this?
My lord, can 3 I have been served today morning itself.
Can 3 is an injunction application.
Yes, my lord. Since your lordship was saying.
No, but what is your defense to the Supriya Ghosh?
Right, my lord. My lord, may I?
Just tell us. I
Yes,
mean, we won't go
in
into
short, I will take only 1 minute. My lord, the appellant herein is a practitioner, legal practitioner in that court itself. Number 1. Number 2, my lord, in the event someone tries to, the allegation has been leveled against the advocates also, representing the husband therein. That they, in connivance with others, this particular wakalatnama had been submitted.
But she is a practitioner, husband is not.
Not. And my lord, if somebody.
So you say the records might have been manipulated?
that is a ground in our opposition. And my lord, apart from that, in the event somebody, that is a normal course of action of a person. Well, in the event somebody wants to impersonate some other person by way of some other
Would
person.
not sign in a different name.
name. And my lord, the learned judge was dealing with the matter for quite a long time.
Or it will consider this
My
as
lord, my lord,
we'll keep all these open for being
Yes.
decided in the appeal.
my lord, in 2009, my lord, I was married to the opposite party. Thereafter, my lord, I went to Durgapur. Initially, my lord, prior to my marriage, my lord, I
Won't
was
go into those at this stage.
And my lord, the maintenance case under 125 and the domestic violence case, both are pending before the same court. She
No,
is
no, no.
contesting.
no.
This will be considered.
It is in Howrah court. Man, it is a
No,
Howrah court.
if it is a order for Rule 27 scenario, we would consider.
And they also.
But here it is. There is no question of new document coming in
And-
because whatever they say is already on record, and your defense will be.
And also they did not approach the same court that see these things have happened. So
We'll do this.
Yes.
We'll keep Can 2 of 2023 along with the opposition reply and the supplementary affidavit for being heard along with the appeal.
Right.
So that these documents and your opposition to that can be considered by us. We'll do that because this is the new ground taken in the appeal. And injunction, we are injunction. Just take a look and
I've read it already.
we'll say that you are not admitting any of the allegations made.
Right.
যেটা বললাম তাই তারপরে Can 3 of 2025 is an application for injunction restraining the respondent husband from remarrying till disposal of the appeal. Push up, since the present suit has been preferred against a divorce decree, comma, unless the injunction prayed for is granted, comma, the appeal itself would be rendered infructuous. Full stop. Accordingly, Can 3 of 2025 is allowed, comma, thereby restraining the respondent husband from contracting any remarriage during the pendency of the appeal. Push up. Next para. Can 2 of 2023 is an application for stay. Full stop. Although otherwise, in view of grant of injunction, comma, the said application would lose relevance, comma, in view of the allegations and counter allegations made in connection with the said application, comma, particularly in the supplementary affidavit filed by the petitioner and the opposition and reply thereto filed by the parties, comma, where a serious allegation has been leveled by the appellant as to the appellant having been impersonated by someone else before the trial court, comma, which is squarely controverted by the respondent, comma, we are of the opinion that the said application along with the connected pleadings thereto should be heard along with the appeal. Full stop. This is all the more so since the allegations and counter allegations leveled in the pleadings made in connection with Can 2 of 2023 have a direct bearing on the outcome of the appeal itself. Full stop. Accordingly, Can 2 of 2023 shall be listed for hearing along with the appeal itself. Full stop. Next para. In view of appearance of the respondent through his learned advocate, service of notice of the appeal is dispensed with. Full stop. There was no previous direction for paper book. Next para. The trial court record shall be called for by special messenger at the cost of the appellant to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal along with Can 2 of 2023 for inclusion in the list for hearing as and when the appeal is made ready for hearing.
Can is to be heard out along with the appeal.
The Bengali saying starts with Satkando Ramayan. Yes. We have said thrice it will be heard along with the appeal, and liberty also to mention along with the appeal. Yes.
Yesterday, I have indicated there was some difficulty.
Yes, you said. He said. So we
May be taken up
tomorrow. On the prayer, you are for the appellant.
Appellate.
On the prayer of the appellant, the matter is adjourned for the day. কালকে এসে বলেছিল তখন
Lordship, item number 12 and 13, Mr. Ramchandra Guchayat is appearing.
Please, sir, please use the microphone.
Mr. Ramchandra Guchayat is appearing for the appellant. He is on his legs, Your Lordship.
You start
kindly-
the matter.
Your Lordship, I am not holding the brief. Your Lordship, kindly make it not today.
No. Start the matter. Somebody has to start the matter. Otherwise, dismiss for default. You are for the respondent.
Your Lordship, then
You are his
fine.
chamber junior.
No. I'm the advocate on record, but because
You're
I
the
was-
advocate on record. We give you 10 minutes time. Prepare yourself. We'll take it up at 12:53.
Your
Pass
Lordship,
over.
I was not.
Take our brief. এটা দাও। এটা ওনাকে দিন। 10 মিনিট বাদে এটা 12:13. Pass over. Prepare yourself. Don't misplace the papers for God's sake.
No, Your Lordship.
Yes. Prepare yourself here. Sit at the side and prepare yourself. Yes. Call on the next.
Lordship, learned advocate Mr. Prosenjit Mukherjee is appearing for the appellant. He is engaged in court.
Refused. You have to move the matter. Either you move or we dismiss for default.
Lordship, on behalf of the respondent, Lordship.
You're also asking for time? No. What is the matter about?
Lordship, they have filed the Lordship 2 applications, Lordship.
Or we are dismissing it for default? Why waste time? If you're asking for time, we are dismissing for default.
Praying for a short pass.
No, refused. We refuse adjournments, particularly to juniors. You prepare yourself also. We'll take it up at 2. But you have to move the matter, not your senior. Where is your brief? Pass over will take up at 2. Pass over till 2. Eta duto সময় নেব। You have to move the matter, tell your junior, tell your senior. এটা দুটো সময় নেব আর ওই মিনিটটা
Also analogous with item
14-15, yes, both. Tell her also.
Yes, but
And help her. Yes. Next.
Well, I am appealing on behalf of the appellant. The appeal is within time. But I am the defendant number 2 before the learned court below.
Right. The suit is for?
The suit is for partition.
What has happened?
Well, the injunction has been allowed by the learned court below. Well, my
No,
point.
this is against the preliminary degree of partition.
No. My lord, I have challenged the interlocutory order of injunction.
Oh,
Order
oh,
13 and Rule 1 and 2.
This has been admitted under Order 41?
No. This is the first time it has come.
Why did you mention it as an application?
Well, I did not mention the matter has come.
Who is Nadim Khan?
And Nadim Khan, my lord, the advocate on record. He did not.
So you are appearing for the appellant, you have to take responsibility. It should appear under the Order 41 heading. Somebody might be watching. We'll take it up as an Order 41 matter.
I'm great.
Since the present appeal has not yet been admitted, let the same be listed tomorrow under the heading Order 41 Rule 11. Tomorrow itself will take up.
I'm grateful,
But if somebody is watching the Order 41 list, he will be
I'm
missing.
I beg your pardon, my lord. I'm great.
কালকে Order 41 হিসেবে নিয়ে করে দেবে। But you will move it.
Yeah, I will.
Yes,
Well,
yes.
I'm
Not
ready.
yeah.
Well, I will ready.
Not yeah.
Yes, ma'am. I will move. Well, I'm ready. I'm ready with the matter. I'm grateful. I'm grateful.
Next.
I'm appearing on behalf of the respondent number 1. Your Lordship.
Yes. Who is for the appellant? On the last occasion, both sides had sought adjournment. On the last occasion, both sides had sought adjournment. Push up today, although the respondent number 1 is represented through counsel. Yes. Take your breath and move the matter. Yes.
Well, there is 2 applications. One is
You have time till 12:53 to finish your matter. Yes.
Lordship, I'll file my affidavit in opposition.
That is not a good excuse. What is your defense? Let us see that.
this is my affidavit of service.
What is the application about?
এটা আরেকটা সেকেন্ড পেজেস কপি মানে
Declaratory suit decreed against you.
suit for eviction.
Suit for eviction?
Yes, Lordship.
Oh, acha. Eviction on the ground of?
2G. I am the tenant.
What is your defense?
My lord,
This is a condonation application.
yes, this is a condonation application.
Can one?
And another one is stay application. My lord,
What is the
there
delay?
2
What is the delay?
202 days delay.
202. What is the expansion?
Explanation is written in my application. My lord, it starts from paragraph number 3 that he was suffering from various ailments. Thereafter, he contacted with me in the
Yes. What do you say to the condonation application?
Your Lordship, the decree is of 9th of April 2024.
They've given some explanation.
Your Lordship, they have stated that only on the ground of unwellness, Your Lordship. Although the advocate on record received the brief as stated in para number 4,
Yes.
5th of June 2024.
Yes.
Thereafter, they have applied for the
So on
certified
5th
copy
of June, they were advised to bring the documents. to the check.
documents. Then they have applied for the certified copy on 23rd of July 2024.
So this 1 month has not been explained.
Yes, Your Lordship.
Yes. Why did you wait for 1 month after being advised?
My lord, the client was suffering from various ailments. Client did not contact during that
That is
1
not even
month.
stated here.
Yes, Your
Yes,
Lordship.
client did not contact.
Your
My lord,
Lordship.
kindly peruse the fact that when this is the only shop room and where from the
We appreciate that, but Ms. Shorkat, the difficulties in para 4 you have said he was under treatment, suffering severely. After getting recovered, approached you 5th of June 2024, advised.
advised to
But then after 1.5 months, he even applied for the certified copy. Length of delay is not material. The reason given is she is right. So 1.5 months, why after that? Because after he recovered, he approached you.
Then he contacted his lower courts advocate. Thereafter,
Lordship, he
he
has two
applied for
sons
the
also.
he applied for the certified copy.
Nothing there. Certified copy he applied. No.
Actually, the person who is evicted from the premises.
Let us see when the certified copy was applied. That will.
But it is annexed in my.
You have said that he has obtained the certified copy.
It is not
No,
annexed.
ma'am. He applied on 21st of June. Not properly stated here. Which is after said fortnight after that. He applied on 21st of June. 5th of June he was advised.
Yes, Lordship.
After 16 days he applied. So within a fortnight. Because he has stated finally certified copy was prepared and handed over on 23rd of July. It was applied on 21st of June. So let us condone the delay.
Yes, Lordship.
We are condoning the delay. Then regarding the stay application, we will hear you. Can 1 of 2024 is an application for condonation of delay in preferring the appeal, which sub next para. Learned counsel for the appellant contents that the appellant was suffering from various ailments, which sub after recovery, comma, the appellant contacted his advocate and being advised apply for certified copy and obtain the same on July 23, 2024. Which of thereafter the memorandum of appeal was prepared and settled and the appeal was filed soon thereafter. Which of next para? What is your name, please? Your name.
Antora De.
D-E.
T-E-Y.
Ms. Antora De, D-E-Y. Appearing for the respondent, comma, controverts the allegations made in the application. Push up, Ms. De points out that in paragraph number 4, it has been stated that the appellant was advised by her learned advocate on June 5, 2024 to bring all documents. Push up. However, comma, the certified copy was obtained only on July 23, 2024. Push up. Thus, comma, it is argued on behalf of the respondent that there is a serious gap in the chain of events as mentioned in the condonation application. Push up next para. On a perusal of the certified copy annexed with the memorandum of appeal, comma, we find that although the certified copy might have been prepared on July 23, 2024, comma, the same was applied for on June 21, 2024, comma, that is after about a fortnight from being advised on June 5, 2024. Full stop. Such time is reasonable, comma, since after being so advised, comma, the appellant must have spent some time in contacting his advocate in the court below and arrange for application for the certified copy. Full stop. Accordingly, comma, on an overall consideration of the pleadings in the application for condonation of delay, comma, we are satisfied that sufficient grounds for the delay have been made out. Full stop. Hence, can 1 of 2024 is allowed, comma, thereby condoning the delay in preferring FAT 390 of 2024. Full stop. The appeal is deemed to stand registered and admitted accordingly. Yes. What is the stay application?
The stay application, there is a procedural latches, my lord. Kindly come to the order number 34, my lord.
এটা একটু শুনে নি তারপর তো।
Last para of the 34, it is annexed in my stay application, page number
34 years. What is the latches?
page number is 30, page number starts from 36,
Which page should you look at?
36 and last paragraph, lordship.
36, yes.
37. My lord, kindly come to page 37, the last paragraph. Considering all these measures, I reject the prayer for the defendant Devashishda supported by medical certificate. I preferred an adjournment application and it was rejected. And fix 9/4/2024 pronouncement for judgment on the basis of material in record. On that,
You are given several opportunities that is recorded. And what is your defense against 2G? Who are you regarding the original tenant?
I am the son of the principal tenant, my lord. I am the
When did he die?
tenant of 1956 Act, my lord.
How can 1956? When did he die?
He was died on 2012, lord.
Then how can 1956 Act apply? That date would be German. There is no case.
I
No
am saying that I am the tenant of 1956. I am not saying that I am inherited the property as per the 1956.
You are the son of the original tenant.
Yes, lord.
Original tenant died on 2012, in 2012. So the time has expired after that 5 years.
My lord, there is a procedural latches. The trial court did not keep the matter.
Don't have a defense. You
for
don't
the
have a prima facie case. Even if you we are asking you on your defense. If you have no defense, then why should we grant you stay? Not in every case.
My lord, there are no scope was given for the argument or the preemptory hearing. No scope was. There is a procedural latches. Fifth, the order was passed, and ninth, the final order was
Even
passed.
if hearing was given to you, your written statement, what is the defense taken in the written statement?
Written statement that is taken. I am not falls under 1997 Act. I fall under 1950.
Not even annexed. Written statement, not even annexed here.
Yes, written statement is annexed in my writ petition.
You don't have a writ
In my
petition.
stay application, lordship, starts from page 41.
41, why? After so many things.
After
Anyway,
the order, my lord.
after the order. 41, let us see your defense.
No knowledge of the above noted suit.
What pandemic COVID? Nothing, no defense at all. Undivided property of the plaintiffs and all. No prima facie case. No stay, sorry.
But this is my only livelihood, my lord.
We'll give you some time, file an undertaking, take instruction.
Kindly give me 6 months time.
If you file an undertaking, we'll definitely give you.
I will file my undertaking.
We'll record that right now. Fair enough. We'll give them 6 months time.
Your
Then-
lordship, 1 month's stay. Please.
My lord, from that shop room, I earned my livelihood.
So
my lord.
1 month, generally 1 year used to be given previously.
Yes, lordship.
Now
I
we
pray
give
for
6 months.
6
Because if the appeal is kept pending, you have levied execution. You have started an execution case.
Your lordship.
They'll set up some
Next
third
day-
party. They'll set up some third party who will claim a right, and there are other aspects. You won't be able to get your position in 10 years. So let us agree to 6
6 months. I will give you the undertaking.
come back tomorrow, you take instruction from your client.
Your lordship.
Can 2 of 2024 is taken up for hearing. Full stop. The suit was decreed by the impugned judgment and decree under the provisions of section 2 within bracket small g of the West Bengal Premises Tenancy Act 1997. Full stop. Upon a perusal of the written statement of the defendant stroke appellant annexed to the stay application and hearing learned counsel for the appellant, comma, we do not find any prima facie case for the appeal to be heard on merits. Full stop. Virtually no defense has been disclosed in the written statement itself. Full stop. Next para, learned counsel for the appellant argues that there were several procedural latches in the appellant not being given adequate opportunity for cross-examination and adduction of evidence. Full stop. Next para, however, comma, we find that the trial court recorded in the relevant order that the appellant had been given sufficient opportunity but had failed to cross-examine PW1. Puts up that apart, comma, since no defense has been disclosed against the section 2 within bracket small g argument, comma, even if an opportunity was given, comma, the same would not inure to any benefit for the defendant, stroke appellant. Full stop, next para, hence, comma, we are inclined to refuse the prayer for stay. Full stop, next para. At this juncture, comma, learned counsel for the appellant on instruction submits that the appellant is agreeable to hand over vacant and peaceful possession of the premises in favor of the respondent if 6 months time is granted to the appellant to leave the premises, comma, since according to the appellant, comma, the suit premises is the only source of livelihood of the appellant. Full stop. Keeping in view such such submissions, comma, we request the learned advocate for the respondent to take instruction as to whether the respondent is agreeable to grant of 6 months time to the appellant for vacating the premises, subject to an undertaking being filed by the appellant in that regard. Pushed up, we grant such opportunity to the respondent, comma, since in any event, comma, there are several devices by which the execution of an eviction decree can be thwarted, full stop. In the event an undertaking is filed by the appellant, comma, the respondent decree holder shall also be saved from such unnecessary procedural wrangles. Full stop. The matter shall be listed tomorrow under the same heading for passing further orders. Take instruction, convince your client 6 months is sufficient.
Shall I have to file the undertaking?
No, not now. When we direct you, we'll give you some time. We'll put it on another date as to be mentioned. We'll file that with a copy to them, pass orders. Thank you.
Practical solution.
Yes.
Item number 1214, my lord, unfortunately.
He will move. That was the understanding.
Kindly, Your Lordship, kindly.
Can 5 first, section 5 first. Yes. What is the delay?
Your Lordship,
Mr. Guchait, you help her.
1696 days of delay.
1696, what is the reason?
Your Lordship, there was pandemic. In the meantime, we have also preferred for review application, but that was rejected. We have contacted many advocates of state advocates, but they have delayed the matter in filing, Your Lordship.
If you have made allegations against advocates, you have to name them and serve them
Your
notices.
Lordship, the letters are
and also
annexed in the condonation of
the officer change.
and even
To the legal remembrancer, what will the legal remembrancer do? You are the state.
yes, Your Lordship.
We are the state.
Your
All these advocates have to be given notice, copies of this. Whoever against whoever you have alleged, we will hear them. That's our standard practice, Mr. Guchait. When you make allegations against an advocate,
no, Your Lordship, that there was
Also, my lord, there is a Panchayat election, my lord. Pandemic situation there 2019.
pandemic situation started 3 months after.
2019 to 2022.
Oh, acha, right.
And all the life were thrown out of
Pandemic,
here.
yes. Let her complete.
Yes, ma'am.
You don't include, let her complete. We are asking her. Let her come to the microphone. Yes. If we feel, we'll call upon you, Mr. Guchait. If you are inclined to dismiss your application, then we'll definitely call upon you before doing that. Yes, ma'am, please come forward. Mr. Guchait will be helping you, your senior. So, 21st of December 2019, the judgment was passed. Pandemic started about 3 months after that. So, limitation. So, what happened after 28th of February 2022, pandemic was lifted. Then
we have filed for the review application, Your Lordship.
Review application is not an alternative of an appeal. You could file both together.
Your Lordship, kindly.
What happened to the review?
That was rejected, Your Lordship.
When?
Page
29th of July
Yes,
2024. You're
Your
not
Lordship, it
ready
was
with the
rejected
brief.
on 29 July 2024.
Yes.
Then, Your Lordship, some of the officers and servants are probably, they were, the DM was,
Oh,
the DM,
they were
yes, Your Lordship,
transferred.
in the paragraph 13, Your Lordship, the DM was transferred.
So how does it matter? The
Your
DM is
Lordship,
transferred or not?
the matter was always get preferred from the
This
DM.
is against what? Compensation?
Yes, Your Lordship. They have preferred a section 18 application.
Section 18 reference that has been passed.
Yes, what do you say?
But the
DMs transferred, what can they do? Obviously, DMs have a role to play.
that is a matter of records. I cannot say about this, man. So far, my response submission in this particular case. So, as a general, my lord, the section 5 should not be opposed. But the things.
Everybody who opposes says that. That I generally don't oppose, but.
But your lordship kindly appreciate to the subsequent some order has been passed when the money execution case. That has not been, my lord, the.
How is that material for condonation of the
No,
delay?
that's not the condonation delay. So, my lord, the condonation delay for the purpose of hearing of the stay application. The stay application is also, my lord, kindly appreciate that has not been.
When we take up the stay application, we'll hear you on that. But condonation, we have. So,
in this case, my lord, already opposition has already dealt with, my lord.
You have filed opposition to this section 5?
Yes, Your Lordship, we have also filed
that
the
may not
reply.
be, I cannot be allowed with.
Very well. Upon hearing learned counsel for the parties, comma, can one of 2024. You are on the state panel also. Then we include her name also, Mr. Uchai. Can one of 2024 is an application for condonation of the delay in preferring the appeal. Push up next para. It is contended by learned counsel for the appellant that the impugned judgment was passed on December 21, 2019, comma, near about the expiry of the limitation period, comma, the COVID-19 crisis started. Pushed up, the consequential lockdowns and restrictions continued till February 28, 2022, comma, whereafter the concerned office of the appellant was heavily engaged due to its administrative function due to the last panchayat elections. Since the election procedure was notified on June 9, 2023, footstep in the meantime, comma, an application for review of the impugned judgment was filed, but the same was dismissed on July 29, 2024. Footstep next para. In the meantime, comma, three district magistrates, comma, three of the district magistrates, Purbo Bardhaman, comma, special land acquisition officer, comma, Purbo Bardhaman, got transferred and the case file did not move. Full stop. Ultimately, comma, thereafter, comma, the appeal was preferred. Full stop. Learned counsel for the respondent opposes the prayer and contends that in the meantime there were several orders passed in connection with the execution case. Full stop. Next para. However, comma, upon hearing learned counsel for the parties, comma, we find that sufficient explanation of the delay has been furnished in the application, which accordingly can 1 of 2024 is allowed, thereby condoning the delay in preferring FAT 250 of 2024, which of the appeal is deemed to stand registered and admitted accordingly. Now the stay application, you are seeking for stay. Mr. Guchait, come. You have argued well. Thank you. Yes. Yes, Mr. Guchait, now your turn.
My lord, we are seeking for stay because, my lord.
Yes.
So far the land, my lord, we acquired the land in the area. That is
how
for
can there be a stay of a money degree?
My lord, because my
deposit the entire amount.
My lord, the reference court has, my lord, assessed the amount that is more higher as because the land is Sali land. The lower court having.
We are not on that. Now, the admitted amount has been disbursed to them. You have got the original amount.
They have received with protest.
No, but then you deposit the entire amount with the registrar. This will be subject to outcome of the usual thing.
Yes, that we can.
That is also, my lord, the execution proceedings and subsequent order already passed. The order for
Let us see that. Let us see that.
যেটা এখন বাড়িয়েছি এটা জমা করে দিচ্ছি পরে ডিসাইড হবে actually my lower court has, my lord,
Oh, they were directed to set apart that sum.
Already amount is deposited.
Then we are not passing any further direction.
Unless, my lord, since the matter is pending before lordships, unless the direction is given, the amount will not be disbursed.
Disbursal at this stage, we cannot bear it. If you get the amount, then I mean, what is the guarantee you will return it when if you lose the matter?
I choose, my lord, lordships pass the order.
But this amount was directed to be set aside, set apart. Yes, Mr. Guchait, please hand over copies of this to Mr. Guchait. Already order has been passed. You don't keep information. I mean, your client.
My lord, I shall take the
That amount has been directed to be set apart from the general PL account. If that be so, the decree, the award has been partially implemented. We can keep it at that stage. Take instruction, come back tomorrow.
Yes.
Some other day.
My lord, the date will be taken up, my lord, next week.
Monday then? Monday? Yes.
Otherwise, they will take the instruction.
Yes, ma'am.
Can 2 of 2024 is an application for stay of the impugned judgment. Full stop. At this juncture, learned counsel for the respondents hands over a copy of an order dated January 15, 2024 passed in the connected money execution case number 79 of 2020, where the executing court had directed the appellant to set apart the awarded amount of rupees 58,09,962 within bracket interest included from the general profit and loss account with scheme ID and description 4877 under the control of the appellant and custody by way of attachment. Puts up next para. Since an order has already been passed, the learned advocate for the appellant is requested to take instructions on the said issue. Pushed up. Let the matter. No, the matter is adjourned till January 27, 2025 to enable learned counsel for the appellant to take such instructions. It will appear on 27.
27, 18 to 28.
তাহলে 28 ওটা করে দিন।
24 হবে আমারও মামলা আছে ট্রাইব্যুনালে কতক্ষণ
নেক্সট
সেম
13 what সেম 12 13 তাহলে একসঙ্গে করে নিয়ে ওটা প্লুরাল করে দিও প্লুরাল করে দিও
ডিলেটা
পিলস ফ্যাপিলস বলে
ট্রাইব্যুনালে মামলা আছে
চেষ্টা করে লাভ
Yes.
Hello, I have served.
That's simple.
Both by way of bail and speed post.
They have received.
The packets are unclaimed, but they are received by bail. The track reports are there. They have opened the bail repeatedly, all of them. So,
Just let us just once shake up the previous order. Mr. Chatterjee, please take your seat. We'll call upon you. We'll just go through the previous order. making this injunction order absolute. এটা absolute করেছে। Affidavit of service filed today be kept on record. Full stop. None appears for the respondents at the time of call, despite substantial service having been effected on the respondents. Full stop. The detailed reasoning for passing an ad interim order was recorded in our order dated December 19, 2024. Full stop. On November 27, 2024, comma, a day after receipt of summons of a suit filed by the appellant against his termination by the respondent school, comma, the impugned letter was issued by the respondent number 4 on behalf of the school, within bracket, of which the appellant was the acting principal, bracket closed.
Not the appellate.
Oh, sorry. Was issued by the respondent number 4 in the capacity of the acting principal of the school, comma, leveling palpably derogatory allegations against the appellant, and also withdrawing the appellant apostrophe experience certificate which had been granted to him despite his prior termination by the school on July 30, 2024. Which of next para, we had recorded, comma, as it also appears from the materials on record, that the motivation behind the issuance of the impugned letter dated November 27, 2024 might have been a vendetta against the appellant and an afterthought after receipt of the summons of the suit instituted by the appellant. Full stop. In view of there being no change of circumstance till date, comma, we do not find any reason to vary the ad interim order passed by us on December 19, 2024. Full stop. In view of the respondents having chosen not to appear despite service, comma, we take up the we dispose of the application itself. Which of accordingly, IA number CAN 1 of 2024 is allowed, comma, thereby restraining the respondents from publishing and stroke or notifying and stroke or circulating the impugned letter dated November 27, 2024, annexed at page 60 of the stay application, and stroke or from putting up the contents of the said letter on social media, comma, print media, comma, electronic media, or in any other media, and stroke or propagate or disseminate the contents of the same in any manner in any social or public platform till the disposal of the appeal. Full stop. The respondent shall remain further restrained by an order of injunction from acting upon the impugned letter dated November 27, 2024 in any manner whatsoever, comma, also till disposal of the appeal. Full stop. There will be no orders to cost. Stop. Next para. The appellant shall put in due requisites within a week from date. Full stop. The trial court records be brought by special messenger at the cost of the appellant to be deposited within a week from date. Stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant, who of liberty to the parties to mention the appeal for inclusion as and when the same is ready for hearing.
But I'm grateful. But I kindly request that I have also submitted the registered packets separately, which have come back.
Affidavit of service একটা কথা প্রথমে বলেছি,
Along with the
কোথাও একটা affidavit of service বলেছি, along with the returned envelopes. যেখানে affidavit of service বলেছি, along with the return recorded.
Great.
Thank you. দুটোর সময় যেটা ফিক্স Yes. What are the applications about? You help her. Yes, please take the microphone.
So there is a section 5 application. There is a delay of 975 days. 975 days.
What is the against what decree are you coming up? Preliminary degree of partition.
Final degree, Lordship.
Final degree of partition. What is the reason for the delay?
Lordship, no notice was served upon the appellant, Lordship.
How did you come to know then?
When the commissioner went for the inspection at that point of time.
Yes, what do you say?
My lord, first of all, kindly consider the report given by the department. The delay is 1954. 1954. 1954. My lord, in the memo, the report has been subscribed.
But whatever number of days they have stated, the explanation remains for the entire period. Because if they first came to know on some particular date and they have given that date.
My lord, first of all, my lord, subject to my lord kind consideration.
Yes.
First, there is a inordinate delay. There is no such explanation. We intend to file a opposition. Because the explanation I want to, my lord, state on my opposition why we are saying that there is no such explanation.
Let us just check the application.
The explanation is so feeble.
Let us just check up once.
Since 7th October 21.
And the
What happened to that order 9 rule 13? No, Mr. Mukherjee can come.
This is pending.
When did you file that order 9 rule 13? On 13th of March 2023. When did you file this appeal?
So this appeal we have filed.
it has been, my lord, the section
19th of September 2024. So what is the explanation from 13th of March? You came to know of the decree. 13th of March 2023, you had filed that order 9 rule 13. That means you came to know of the decree then.
Yeah, against the final decree, Lordship, the order 9 rule 13 is pending. Subsequently, when the partition commissioner went to the spot and delivered the position, Lordship, my contention is
You are challenging the preliminary decree.
No, final decree. Lordship, Lordship, at present, I am agree with the sayer.
No, we don't understand. The preliminary degree was also passed expertise.
Yes.
Final degree also expertise.
Expert.
Partition commissioner goes between the preliminary and the final degree, not after the final degree.
Now, Lordship, my case is the partition commission, all valuable, Lordship, the property is given to the plaintiff.
That's a different thing. Why should you condone the delay at all? You filed an order 9 rule 13 against the expertise preliminary degree. Because if the commissioner went to the spot, then at that point of time, no final degree could have been passed. Only after partition commissioner's report, the final degree is passed.
The final decree passed on 7th October 21. Lordship, kindly come page 10 of my...
No. One second. Let us come to para 6 of your application. There is no explanation. He's right. Mr. Prasad is right. Come to para 6 of your application. Where is the explanation?
And it is very much stated that 7/10/2021, the partition commissioner had gone to the place.
Yes.
He immediately came to know.
Yes.
And thereafter, he had taken the stay for Order 9, Rule 13 in 13th of March 2023.
No, Mr. Mukherjee.
Lordship, kindly, I'm just saying, Lordship,
Yes.
kindly paragraph 3. Subsequently, Partition Commission appointed, and the concerned Partition Commission at the instigation of the plaintiff has allotted the valuable plots to the plaintiff and prepared the Partition Commissioner report and submitted the same on 7th October 2021. On that particular day, Lordship, the final report has been accepted, final decree passed.
So after the pronouncement of the judgment in preliminary form, when the partition, how did you come to know? That's not clear from this entire application. How did you derive knowledge? You have stated when the partition, page 7, when the partition commissioner came to the spot of the property for inspection, the present appellant got knowledge of the suit. So partition commissioner submitted his report on 7th of October 2021.
Yes.
He must have come to the spot earlier than that.
Lordship, so far my instruction,
whatever is your instruction, one cannot, the partition commission cannot
Lordship,
file a report before going to the spot.
my case is on 7th October 2021. I had no knowledge regarding the partition commissioner's report. And
No, the next sentence you say, when the partition commissioner came to the spot of the property for inspection, the present appellant got the knowledge of the suit.
Yes, that is after 7th October 2021.
What is the business of the partition commissioner after submission of the report to go to the spot? The partition commissioner's job is over when he submits the report.
Yes, on 7th October 2021.
On 7th October, you have stated he submitted the report. The partition commissioner goes to the property obviously prior to submission of the report.
That is the Lordship.
So, and next sentence you say when he went to the spot, you got knowledge. Therefore, your knowledge must have been before October 2021. No ground, Mr. Mukherjee.
No, Lordship, after 21, Lordship, I filed this Order 9 Rule 13 on 13 March 2023.
First of all, there is 2 years delay from that also, 1.5 years. Secondly, partition commissioners, I think we are very clear. We need not repeat ourselves again and again. You have written it, you know better. If the partition commissioner submitted his report on 7th of October 2021, and if you state that you came to know of the suit when the commissioner came to the spot, then the commissioner must have gone to the spot prior to submission of his report. That means before 7th October 2021. You came to know on 7th October 2021 and you filed the appeal in September 2024.
So 13 March 2023, Lordship, I filed this Order 9 Rule 13.
No. We will dismiss the right.
I'm grateful.
Lordship, this is an absolutely ex parte, Lordship. No notice has been served. Lordship, kindly call for the records. I am not praying for any stay or condemnation of delay. Lordship, kindly call for the LTR that no
If we
notice has been
don't pray
served.
for condemnation of delay, how can we call for the record? Why should we?
Only that this, so far
Your
the
appeal is
Maharaj is
honest. Your
concerned.
appeal is honest in the eye of law.
So
Can 1 of 2024 is an application for condonation of delay in preferring the appeal. Full stop, next para. Learned counsel for the appellant submits that the ex parte decree which has been challenged was passed, derogates the law. Full stop, next para. Learned counsel for the respondents rightly points out that no explanation whatsoever has been furnished for the delay in preferring the appeal. Full stop. In paragraph number 6 of the condonation application, comma, the appellant has admitted that the appellant derived knowledge of the suit when the partition commissioner came to the spot for inspection. Full stop, next para. It is also admitted in the same paragraph that the partition commissioner submitted his report on October 7, 2021. Full stop. It is everybody apostrophe's knowledge that a partition commissioner is appointed and holds inspection only upon passing of the preliminary decree. Full stop. The report of the commissioner cannot be submitted prior to his visiting the locale. Full stop. It is obvious that the partition commissioner must have visited the property for inspection prior to submission of his report on October 7, 2021. Full stop. Since the appellant categorically admits having knowledge of the suit when the commissioner came to the spot, comma, the knowledge has to be attributed at least prior to October 7, 2021, comma, when the partition commissioner's report was submitted. Full stop. The present appeal, however, has been filed inordinately long thereafter, only on September 13, 2024. Full stop. Next para. Even an application under Order 9 Rule 13 of the Code of Civil Procedure was filed as per the averment of the appellant on March 13, 2023, that is more than a year, more than 1.5 years after the after the submission of the commissioner's report. Full stop. Be that as it may, no explanation whatsoever has been given for the huge delay from prior to October 7, 2021, when the appellant admittedly came to know of the suit, till September 13, 2024, when the present appeal was filed. Full stop. Thus, even on the face of the application for condonation of delay, no ground whatsoever has been made out for the delay in preferring the appeal. Full stop. Accordingly, Can 1 of 2024 is dismissed on contest. Full stop. Consequentially, FAT 294 of 2024 is dismissed as time barred. Full stop. Can 2 of 2024 also stands dismissed accordingly. No arrest to cost.
So let the Order 9 Rule 13 be expedited.
We shall say nothing. Next.
Both them. There are two matters, my lord. Another.
Two matters mean another appeal, same ground.
Another appeal by the some other defendant. The same explanation, same paragraph, same everything is same.
Dates are also same.
Yes, yes. So to
Same decree, Lordship.
Copy paste.
No, the Lordship, same decree, same defendants. Here in this earlier occasion, the appellant, Lordship, is admittedly no notice has been served.
Say copy paste. Para 6 is a copy paste. So same order, একই order copy paste করে ওটা দিয়ে দিই। শুধু FAT নাম্বারটা আলাদা হবে। একটা FAT number 294, একটা FAT number 290.
I'm getting.
The date of filing is also same. We should check up this.
Yes, appeal, date of filing of the appeal, sir.
No. Yes. Just let us check up. না 290 হচ্ছে ডেট অফ ফাইলিং হচ্ছে সেপ্টেম্বর 12, 2024। যেখানে যেখানে সেপ্টেম্বর 13 আছে ওটা সেপ্টেম্বর 12 হয়ে যাবে FAT 290 টায়। থ্যাংক ইউ।
Lord, item number 19 and 20, Lord, are my appeals, Lord. One is from a.
Yes.
The first one is against the suit, Lord, for declaration of tenancy rights.
Right.
Which has been decreed. And
Yes.
Lord, my counterclaim is item number 20 that has been dismissed. Counterclaim for eviction of Lord trespasser. Lord, these applications are coming up for the first time. Lord, kindly permits me to serve, and in the meantime, Lord, injunction not so that they don't encumber the property in the meantime.
They've already taken possession.
Lord, they are in possession. My suit, Lord, for my counterclaim for eviction of trespasser, and their Lord suit for declaration of tenancy right.
Oh, their suit was decreed.
Their suit was decreed. My counterclaim was dismissed.
Very well.
Lord, one thing I must indicate, Lord, the certified copy of the decree has been applied for, Lord, already, but Lord, unfortunately, Lord, the department has not made it ready. So, Lord, that Lord, on the next occasion, I might be in a position, Lord, to file both.
No, you have filed certified copies of both the decrees in one of the appeals.
No, Lord, none of them are available. I have applied for the slip is there.
No,
Lord,
trial code has
the website. Yes. Lord, the website certified website copy is there, Lord, but the department has not made the decrees ready.
Learned counsel for the appellant in both the matters submits that the certified copies of the judgment and degree of the trial court could not be furnished, since despite the appellants having applied for the same the certified copies have not yet been made ready. Push up accordingly, the appellants are granted leave to file the certified copies of the judgment and degree of the trial court as soon as those are available to the appellants in the department. Push up next para. The appeals arise out of the out of a decree passed in a suit filed by the plaintiff stroke respondent seeking the declaration of his tenancy right, full stop. While such suit was decreed, comma, the counterclaim filed by the defendants appellants for eviction of the plaintiff as trespasser was dismissed. Full stop. Accordingly, two appeals have been filed, comma, respectively against the dismissal of the respectively against the suit, respectively against the suit being decreed and the counterclaim being dismissed. Full stop. Next para. Upon considering the materials on record, comma, we find sufficient prima facie case to hear the appeals on merit. Full stop. Accordingly, Can 1 of 2025 filed in connection with FAT 5 of Accordingly, the appellant shall serve copies of Can 1 of 2025 filed in connection with both FAT 4 of 2025 as well as FAT 5 of 2025 on the plaintiff respondent number 1, indicating that the applications shall be listed for hearing on February 17, 2025, when the appellant shall file an affidavit of service to that effect. Push up next para. There shall be stay, the plaintiff stroke respondent number 1 shall remain restrained by an order of injunction from creating any third party interest, comma, dealing with and or encumbering the suit property in any manner till disposal of the injunction application bearing Can 1 of 2025 in FAT 5 of 2025. Pushed up. Yes, this much. Because there is no scope of any stay on the other.
No scope of stay. My lord is keeping the matters returnable, my lord, on
17th February. 17th.
Lord, any day prior, my lord, subject to your lordship's convenience. Lord.
We are on 21st, so you will get some time to serve copy. You have granted injunction.
It's in Bagbajar area, so Lord, only one.
You have granted injunction, Mr. Kormaka. What is it?
Very.
Yes.
My lord, I am appearing on behalf of the respondent.
Your lordship, I am.
You don't have a right of hearing now. So take a seat.
Your lordship.
When we hear the application, if we hear the application, then we'll hear. Yes.
I am appearing on behalf of the
condonation of delay first.
It has
in condonation of delay, you have a right of hearing. It has been.
It has been condoned in the previous occasion, and your lordship had directed us to cure certain defects. We have already cured that.
So now the appeal is appearing under order of attorney. Yes. What is the substantial question of law?
Your lordship, Mr. Shafiullah Mandal is there.
Mr. Shafiullah Mandal cannot be a substantial question of law. He is a substantial question of fact.
Can short passover be
granted? No passover. Move the matter. What is the ground?
Your lordship,
judgment of affirmance. Both the courts will have dismissed this. Your suit has been dismissed, or
yes,
their suit has been decreed against you.
Their suit has been decreed.
What is the suit for?
This is an eviction suit.
Eviction on the ground of?
That we are defaulter.
Defaulter in rent, payment of rent.
Yeah, payment of.
Only
yes,
that.
Your lordship.
Only that.
Yes, your lordship. If your lordship will see the page number 27, that is the page number 7 of the judgment of the trial judge.
Page 7 of trial judge?
Yes.
Yes.
Can I read out the issue number 5?
Yes.
This issue relates to whether the defendants are defaulters in respect of payment of rent. It is admitted position that the last time the rent was rupees 150 per month from Exhibit D series.
No, this was a suit filed under section 106 of the Transfer Property Act.
Yes, your lordship.
So what is the question of default? 106 automatically entitles them to a decree.
Your lordship, if you will see, kindly see the matter that that the issue was in the conclusion, thus the issue under consideration and decided accordingly. But in whose favor it is not mentioned here?
No, the defaulter is unnecessary. I mean, defaulter or not defaulter, if they have served, They proved the service of notice under 106.
Your lordship, the service was service of notice was not done in proper manner because it was not served upon the all the defendants.
What is the finding on that?
Your lordship, if you will see the page number 9 of the trial judge's copy, that it has been mentioned in the 6th line. If the eviction notice is served upon any of the defendants, that is sufficient service.
It was a joint tenancy.
Yes, your lordship.
Yes, that is sufficient.
Your lordship, it has not been served upon all the defendants. So
let your senior come. You have tried your very best. We'll pass it over.
Grateful, your lordship.
Pass over whenever he comes. Mention and we'll take up the matter.
Grateful, your lordship.
When will he come? Where is he stuck up?
He is on the way from Waqf board. He is going to Waqf board. He is coming.
On the prayer of the appellant, the matter is adjourned for the day. Come back tomorrow.
Your lordship. Grateful, your lordship.
Thank you. You have tried very well. You are Mr.
Dhirodatta Chaudhuri.
Yes.
Grateful, your lordship.
Thank you.
This matter, your lordship had the occasion to consider on a previous occasion on 9th of December, your lordship. Unfortunately, it transpired after I made my submissions that was an order arising from Alipur court. So your lordship did not have the requisite jurisdiction at that relevant point of time. So this matter was directed to go out of list with liberty to mention before appropriate determination.
But now
now in the meantime, certain subsequent events have transpired.
Like change of
unfortunately, including inter alia. There are more unfortunate circumstances that have transpired in the interregnum. But be that as it may, now we are before your lordship again. I will just remind your lordship what the matter was about very briefly. I had claimed as a licensee. I was in occupation of the premises right from 2006. 2006 to 2021, uninterrupted, unquestioned, uncontroverted possession. I carry on my business. I obtain various licenses, etc. All that I have furnished on the record. Now in 2021, suddenly we are faced with some miscreants who are seeking to evict us forcefully. Upon inquiry, we come to know that these are bank people. Upon inquiry, we come to know upon our possession, subsequent upon the factum of license, a mortgage was created on the premises in favor of the bank. Now the bank says, since this property has been mortgaged with the bank can evict me. The important point to note is the licensor never terminated the license. The licensor never raised any issue pertaining to the validity of my license. Faced with such circumstance, I'll take your lordship through the relevant facts. Faced with such circumstance,
what right does a licensor have? If
licensor,
you're a pre-mortgage tenant, then we could have understood.
I'm a pre-mortgage tenant.
Not a tenant, a license.
Not a tenant, licensee. Now, faced with this circumstance, may I just seek to...
Very well.
Faced with this circumstance, I file a suit seeking a declaration as a licensee over the premises.
Then they are also trying to bypass the Surfacey Act.
No, I'm not.
So,
now, in that
bad on all counts. I mean,
in that suit,
only one count.
Your lordship will kindly bear with me.
What change of circumstances happened? The Surfacey Act has been abolished.
No.
Otherwise, you are gone. Nothing in your case.
I file the suit. In the suit, I array the bank as respondent number 4. The bank is the only party contesting the suit.
He's for the lucky bank.
Yes. Yes. Now we obtain an injunction order back in 2021. That order of injunction continues. Then, by the impugned order of 1st of March 2024, that injunction order is vacated. Your lordship will straight away kindly for mine. And what is the point? To straight away answer your lordship's query. What is my point? The law in regard to the rights and entitlements of any other party in possession of a premise are absolutely settled, and it is strike law. Bajrang Samsundarlal Jalan, confirmed by Hemraj. I will cite both judgments at the appropriate stage. The law is that once the property is mortgaged, a 13.2 and the subsequent proceedings under 13.4 proceeds with the property warts and all, together with all encumbrances and all rights and interests that has been created validly. The only interdict of that right is that right should not have been created post-mortgage without the consent of the bank. Now, in the instant case, it is an undisputed fact that the right had been created prior to the creation of mortgage. That right is unassailed.
Does any of those cases deal with cases of licensees or all deal with tenancies?
They all deal with tenancy, your lordship. But the subject matter of those proceedings are also inter alia possession and in settled possession. And in the context of tenancy, they say registered instrument, this, that, 65A, if it is created subsequently. Now, my contention is, and that is before the, that is the question that is there in the suit, is that what is my status? Now, while I was enjoying an injunction, subsequently, the order of injunction was vacated only on the ground that this subject matter is the subject matter of a surfacey proceeding. So,
13-4 notice was issued.
Correct. Impugned order. I'm led by Mr. Basu.
Then all the more the suit is not maintainable.
Yes. Point is very simple.
Yes. Undoubtedly.
Settle possession prior to mortgage. Documents of mortgage clearly depict that my client is in possession. Nothing more is required. If it is post-mortgage, I'm no right to kicked out.
No, post-mortgage, you will be kicked out, but pre-mortgage licensee will be shown the way out.
No, cannot. That is a required decision.
A bit more courtesy.
They are required decision. My lord, no, Supreme Court says my possession is either licensee, owner, licensee, trespasser, tenant.
You are admittedly a licensee.
Either of the mode, an adjudication is necessary to evict me.
Licensee, for license, what adjudication?
But if I have a licensee, if today
you don't have the protection of the rent control laws.
No, may not be, but then the document of license will say
you go with the mortgager, you go with your licensor.
I am licensed, so I want possession.
You go with your licensor was the mortgager.
Prior to that, he create this license.
License is not a creation at all. License is a.
See the language. Can you see the language?
You file a suit for declaration that you are licensed.
Yes. I have filed a suit. The suit and injunction was granted.
Declaration that you are a licensee.
Suit is
it was vacated under Order 39 Rule 4 or at the final hearing.
Order 39 Rule 4, but the nature of the vacation is, my lord, will surprise.
No, you got an ad interim order. And now the 39(1)(2) application has been dismissed along with the 39(4) must be.
Now, my lord, can you see the conduct also?
For whose conduct?
The bank's conduct. Bank participated in the proceeding. Bank, no, my lord, here your lordship's court, the other day matter was taken up for hearing. My lord was season of the matter. In view of the lack of determination, it was gone to the other court. Matter could not be heard. Keeping this in mind, bank came with force and ousted me.
Oh, you're evicted now.
Yes. During this,
what was the
26? That is the other subsequent event I was.
No, but what is the injunction sought for protecting your position?
Now I am filing further application.
Further application for?
I will be praying for repossession. At least, my lord, no third party interest should be created.
No.
Kindly come to the order appeal against. Kindly come to the order appeal against.
No, you did not mention before the other bench having determination.
Just mention, my lord, could not be taken up for hearing. My lord knows.
No, I don't know.
Oh, my lord is there. Sorry, I forgot that.
I couldn't.
I forgot that my lord is that
how
side.
can we know what happens inside?
Previously, my lord used to know these things.
You are confining us here for the whole day and we are supposed to know. Unless you say we don't know.
My lord, kindly be satisfied. Kindly come take my application. That is Can 2, the present application.
Let us look into the impugned order first.
I will come. Before that, my lord, I will one page I will show to you, lord. See, 134.
Can 2, 134.
130. I am wrong. Now, my lord, it said it's a tenancy.
Who says?
Kindly come to 134. This is the deed of mortgage, State Bank of India. Kindly come to clause C. For all encumbrances, the mortgage properties are in our physical possession, within bracket, a portion of the property is under tenancy occupation on monthly rent.
You file a suit for declaration that you are
Let me
licensed.
check up what I have said.
It's contrary to your plaint case.
Let me check out what I have said. But whatever I pray, a document is required to be constituted. This document has to be constituted.
Any rent receipt?
No, these are say it is a perpetual license.
Your suit, then your suit goes. If your suit goes, your injunction also goes.
Timing, I am not saying, Your Lordship. For the timing, I want to show to Your Lordship from this document that my possession is pre-mortgage possession. Whatever nature.
Possession, no.
But the mortgage deed itself
says that there is a tenant, a party is tenanted. We don't know whether you are the tenant, whether there is actually a tenancy. Just because the mortgage says you cannot.
Page 92.
Mortgage says and accepted by the bank.
Page 92 to the chitti ache of the can one. Page 92.
এতেও আছে এতেও আছে টাকা তো 2 নম্বর এদিক ওদিক করতে গেলে জয় জিরাবাটে গেছে this document I want to show to your lordship. This is the creation of mortgage, and mortgage letter itself says that
probably this is the creation of the tenancy also for the first
that is there page. Yes, kindly come to the 57 also there later.
57. You cannot make out the case contrary to your plaint.
No, I'm not. I just only showed your lordship that I
possession.
I request your lordship to call out only that I am in possession.
Very well. 57.
57 is the letter.
Anag Enterprises is the mortgager, the land, your lessor, or license or whatever. This is
Free of cost.
The bank cannot say anything about that, free of cost or no cost.
No, then
you are relying on this document.
Bank cannot say anything.
Keep shut. We are saying free of cost. Tenancy free of cost.
Well, some other consideration may be there. What the my lord will prejudge this issue today?
What prejudge?
No, this is a prejudging. A document I rely on.
What is there to judge here? Mr. Basu, this is to certify, they certify that they have allotted 340 square feet to you for your day-to-day work free of cost. It's a day-to-day licensee. It's DDI Indian license, license to use the property.
For the timing, I accepted that. I am accepting my lord's order.
We have no objection in running their business in the aforesaid area and give.
This is I want to only to show to your lordship that this is a pre-mortgage possession granted to me. This is only nothing else.
This is not even a possession. A day-to-day license to work day-to-day free of cost.
This is in isolation.
It's not even possession.
Kindly
no exclusive possession.
Kindly don't read this in isolation. Kindly read it with the mortgage deed or mortgage letter that I have shown to your lordship.
We can't attribute this portion of the property under tenancy occupation to you at all. You are not named. Nothing is stated regarding which portion. So how can we attribute tenancy to you?
At least, my lord, that part of the occupation.
Mr. Basu, then you don't understand. Not only, obviously we do understand.
No,
I mean, page 134 verses 57 makes out a palpably contrary case for you. You rely on contrary documents, which is contrary to your plaint case.
I am relying only on my plaint. Only this document I have shown 137 to show that I am in possession. I was in possession in terms of a document created prior to mortgage. And the bank is no of the fish fact.
Yes.
Bank document is this. This much I can, this is clear to my lord. Now, my lord, kindly come to the order. Page tab also. Now, if my lord, kindly come to page 202 of this second application.
202, yes.
39.4 is being discussed now.
Yes. This is not restricted to 39.4 only because the injunction is So
taken up for hearing.
we shall not restrict ourselves to
No, no.
39.4
Then
considerations.
my lord, certain parameters has to be fulfilled. I am not on that.
Exactly.
It will be narrower. I
Much
cannot.
narrower for them.
That's why I will not say that.
But this is that's
fact
why
remains. Fact remains that entire
we
application
obviously
has to now-
understand, Mr. Bose. You already know what next questions we'll ask you, and we also know what next answers will be given by you.
No, I don't.
And you know the fate of the matter.
No, I don't know.
Yes.
One Justice Bhaskar Bhattacharya put me this question directly. We cannot say that Mr. Basu does not know the law and what else.
No, you know, we go one step further. You know what questions we'll ask you next, and we know what answers you'll give next. And the rest of them will also know soon.
We cannot say Mr. Basu does not know the law. My lord, what else my lord is saying? My lord, kindly come
Yes.
to 204.
104.
First paragraph. I will not travel with the entire facts are known to everybody. On perusal, it appears to me the learned advocate of the defendant claimed that the here plaintiff made the bank party to the suit, who is defendant number 4. Learned advocate who submitted that the suit property falls under Surfacey Act. This is a submission. Learned advocate of the plaintiff raised objection and submitted that before the property mortgage tenancy created prior to that. Learned advocate also submitted that the Surfacey Act will not apply as plaintiff is not a mortgagor nor guarantor of the property. Plaintiff claimed himself as the monthly tenant of the suit property and possesses the suit property from the rightful owner, that is the defendant number 1. It appears to me that the plaintiff claimed himself as the monthly tenant under the defendant number 1. It is admitted fact that the suit property mortgage and the bank sent the notice as such and such. Plaintiff claimed himself as in possessor of the suit property. It is another fact that he is not the owner, the defendant number 1 is the owner, and the mortgage is property then, which reason the property mortgage, it is separate matter not related to the suit. But bank, since the notice under Surfacey Act, then the matter comes under the Surfacey Act. This finding, I am, my lord, not correct according to me. Notice sent to my
If the bank sends a
landlord.
notice under the Surfacey Act, it does not come within the purview of Surfacey Act.
Not subject to that. My suit is for
If you
declaration.
file a suit under section 9 of the Civil Procedure Code, it does not come under the purview of Civil Procedure Code.
What I am saying, my lord, I am submitting, my lord, a notice sent to my landlord.
Mortgage to bank, in any event, it's a Surfacey scenario.
That's why the suit, that I am the pre-mortgage tenant.
But tenant.
Let us see what has been stated in the plaint.
See paragraph 5 of the plaint. See your prayer. We have seen paragraph 5.
Finished already.
Yes. And para 6, which is again contradictory to that.
I'll kindly come to
Para 5, first sentence, please.
Let me see the prayer.
We have seen. You have to check up.
License.
Irrevocable license under the Easement Act in West Bengal.
Prayer can be molded. Easement Act.
Molded.
Easement Act is no matter of application in. The
And para 5.
Principle may apply.
Para 5.
No, kindly come to this plaint. This is the plaint.
Plaint para 5.
But suit has not been dismissed.
We'll ensure that. There is precedent of that. You have suffered. Yes. You know, you are the beneficiary.
Not that. I am submitting, my lord.
You say the plaintiff company was granted a license for running its business.
Yes. I am saying I am a licensee. This is my declaration. My lord, Easement Act, forget that. I am a licensee, I can pray a declaration.
Yes.
That I have prayed. And suit, injunction granted. Now kindly see how this injunction was vacated. What is the reason behind that?
What is it?
Then kindly come the suit. But the bank sent the notice under Surfacey Act. Then the matter comes under Surfacey Act between defendant number 1 and defendant number 2 and 4. Not between plaintiff and the defendant number 1. This is the finding of the court. Then, my lord, kindly, these judgments were relied upon. In this citation, I have gone through the citations and it appears to me that their bank is not lesser, but the defendant number 1 is lesser, who tried to throw out the plaintiff, it cannot be said. This is the reasoning. Then, from the above citations and discussions, it appears to me that though plaintiff claimed himself as the monthly tenant, but already the Surfacey notice sent to the defendant number 1 by the defendant number 4, who is the bank. So, in this respect, balance of convenience, inconvenience not goes in favor of the plaintiff, and there no question arise irreparable loss and injury as defendant number 4 sent notice to the defendant number 1, and the plaintiff is not party to that matter. This is the ground. Its separate proceedings where plaintiff by his civil suit cannot want to stop the proceedings. As plaintiff has relation with the defendant number one, but in separate proceeding of lesser he cannot get
It's
involved.
good that she could finish a sentence.
Yes. But the reasoning, what he intend to say?
The convenience, balance of convenience and inconvenience not goes in favor of plaintiff.
English is like me, well, I forget that English. He intend to say that this surface is between the defendant, the for and the bank. And there is no threat of disposition. He will not.
We'll supply the reasons.
Well, this is the reason given.
Some reason has been given, we'll supply the correct reason.
Reason
If
is-
there was devoid, if it was devoid of reasons, then we could not supply.
Well,
Some reasons have been given, we will supplant.
This is the devoid of reason.
No, no.
Saying
Favor-
anything will, well, not. Anything has been said. That you are not at threat of disposition. At the instance of the bank.
She has managed to say that it is a separate proceeding where plaintiff by the civil suit cannot want to stop the proceeding. Surfacey Act mean.
Not stopping. But this is a, well, your
If
lord.
you get an injunction, then it will be stopping the Surfacey proceeding.
No, my position, let them sell.
You have a right under the Surfacey Act to move as a third party also, whoever affected.
Probably I cannot. Because
Absolutely you can. 13(4) measure, anybody and everybody affected can go. That's settled.
perhaps I am not the tenant. The it was taken. Who can save the measures? The back part.
Please read out the language of this section.
Statute are there.
Section 17. Just see section, say read out sections. Just read out the first few words.
Section 17, my lord is speaking about. Any person, including borrower.
Stop.
Yes.
Period.
Hello?
Period. Stop. That's sufficient.
Probably
You fall within that.
your lordship. Madia chemical से paragraph टा बात. This is those line of cases, my lord. Your lordship is regularly dealing with, my lord, the land reforms matters, land reforms. But the suit is barred. If I file a suit for declaration, that is maintainable.
Para 50, the new judgment, देखो Supreme Court 2023, 50.
That way.
Obtaining.
But kindly come to paragraph 50.
50, 51, 52.
Parameter section टा बात.
$50.
50, 50. 50, 51 and 52.
Mhm.
And section 34, this parameter with RDBX.
এর মধ্যেই আছে।
এর মধ্যে আছে, এই তো RDBX।
এটা ইন্টারপ্রেট করিতে থাকে।
হ্যাঁ, এটা ইন্টারপ্রেট করেছে 18টা। আই এম সেইং সেম উইল হোল্ড ফর 34 বিকজ ইট ইজ প্যারামেটেরিয়াল, মানে সেম।
What was the question there?
Section 18 probably was the
Yes.
subject matter. 18 bar in the RDB Act.
Civil court are ousted or not.
Well, ouster of jurisdiction. My lord, ouster of jurisdiction must be very clear. That's why I was, my lord, reminding a lot.
Thus of the view that there is no provision in the RDB Act by which the remedy, para 45, by which the remedy of a civil suit by a defendant in a claim by the bank is ousted.
My question framed, my lord.
But Surfacey Act is probably different. I mean,
No, Surfacey Act, section 34 also same. Civil court has no jurisdiction. So interpreting that, it said That is a suit for declaration. Like, my lord, I was just giving an instance of.
No, RDB Act has a similar, what is a similar provision in that?
34.
No,
18. 18 has been.
Can you read out 18 once?
Yes. On or from the appointed date, no court or other authority shall have or to be entitled to exercise any jurisdiction, power, authority, except by the Supreme Court or such and such, in relation to the matter specified in section 17. Section 34. No civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which a date recovery tribunal or the appellate tribunal is empowered by or under this act to determine, and no injunction shall be granted by any court or other authority. Like, my lord, kindly, we are frequent with, my lord, land reform proceedings. 50 is a bar. That because the record of right cannot be corrected.
No, that's only if it's consequential.
I'm damn saying here it is also consequential. This injunction I have prayed for, because if the injunction is not prayed for, not granted, my suit will infructuous. 34 measure, we have not asked for any stay, nothing. And I
Seeking a bare declaration is not. You seek a declaration that you are a licensee.
Licensee means I will be evicted in due process of law.
Surfacey Act is due process of law. And if a remedy before the why invoke the civil court jurisdiction? There is a specific bar.
Of Bajrang Samsung, the Surfacey Act was considered.
My submission is, if the civil court has a jurisdiction to entertain, I could not say anything if it is post mortgage. I could not serve anything. My right, whatever right is emanating from a document which is pre-mortgage.
Oh, it a tenancy perspective.
Para 56 answers the question. All right.
In this context, my lord, my humble submission is suit is maintainable. And they are participating in the proceeding. They apply before your lordship's court in civil division jurisdiction, get it expedited the suit. And the suit
Give this citation to Mr. Rai. This is not, no, this is not Mandia. Bank of Rajasthan. Give the citation to.
Page 1.
2023 1 SCC 1.
So this part I am showing only for the purpose the suit is maintainable. If the suit is maintainable, when the order has been passed granting relief in aid of the suit. Paragraph 50. এটা ডিসাইড করেছে ইস্যুটা হচ্ছে তো এখানে আছে
You have to look at para 45 and 56 also. 45, 50 to 52
yes.
and 56.
Yes, I have shown to you. Question is, my lord, question put forward at the before the held, yes, at page 4. Is the jurisdiction of a civil court to try a suit by a borrower, even against borrower, against a bank or financial institution ousted by the virtue of the scheme of the RDB Act in relation to the proceedings for recovery of debt by the bank and financial institution? So it made little open. Although, my lord, it is the enactment is a special enactment, and for speedy recovery of the money, in spite of those things, my lord, this judgment gave.
No, RDB Act was also that.
Also that.
That was also that.
It is more than onerous. Surfacey Act. In this context, my prayer would be, my lord, this is on law, but I request you, lordship, to see the conduct of financial institution Article 2 of authority. Here is contesting the proceeding, appearing before my lord in this particular matter heard by your lordship, and in spite of that, my lord, taking advantage that matter is pending, could not be taken up for hearing, my lord, the poison has been taken.
There was no injunction.
No.
How can you get benefit of 144 even? This application has become infructuous.
I know, but there is a judgment of the apex court where there is a interim order subsisting, it expired. And possession taken.
Yet there was no interim order at all.
I'm saying interim order subsisting, he is participating in the proceeding by through counsel. So counsel is appearing. They are taking steps for.
But on merits, you don't have a case. And the licensee does not have such a right.
But then my lord is prejudging the issue.
What prejudging your declaration? We are going by your declaration, your plaint.
What is the suit? Suit is for declaration of my tenancy, and in aid of that suit, I have filed an application that protect my possession. That has been granted. And 13.4 allowed on the ground that no, you have no threat of dispossession because Surfacey is against landlord. Right. My lord, it is probably my lord is known to my lord. My lord has dealt with this. 2019, 9 Supreme Court cases 94. Correct. 24.1 immediately my lord will say valid tenancy. I will submit.
When is that? Which paragraph?
24.
কেসটা ওরা লে করেছে in the context of tenancy কিন্তু আমাদের কেসটা
24 years.
24.1 my lord don't stop there. Valid tenancy starts. Here I have a possessory right. But
all the judgments are mostly on tenancy.
Maybe, my lord. Tenancy, whether tenancy or no tenancy, so you decide in a suit.
In what suit? In a suit in which you have asked for declaration that you are a licensee. It will be decided that you are a tenant. Tenancy or not.
Even if it is licensee decided.
Then you do not come within the fold of this valid tenancy.
Subject to my lord correction. Yes.
Valid tenancy and license are in Mr. Basu, you know the distinction.
No,
exclusive position is given in and
here is also exclusive position.
Licensee, no. Licensee, your position is always at jeopardy.
No.
And not only that, you in that page 57 document and para 5 of your plaint, para 7 of your plaint, you have stated that you are permitted to do day-to-day business. That is the language used.
But a suit is pending.
That does not by itself mean anything.
A suit is pending, and this judgment, my lord, kindly see all the judgments is on the context that don't dispossess a possessory right which is pre-existing of mortgage. This is the, my lord, ratio of these judgments.
No interference.
If a pre-existing occupation is disturbed by Surfacey Act, then, my lord, these judgments, validly, my lord, are not.
You could have gone under section 17 before the death recovery trial.
My lord,
that was your remedy.
Not challenging that.
You're not challenging what? You're challenging the Surfacey action. You are seeking an injunction restraining them from disturbing you in the teeth of the 13.4 notice.
This is the problem. I am not challenging Surfacey Act. I cannot challenge.
In the teeth of the 13.4 notice, you are not challenging, you had to challenge.
Whatever you are doing, you do. 13.4 on the Surfacey Act.
They have done precisely that.
Don't touch me.
They have done precisely that. Under 13.4, they have taken possession.
How can he take possession from me? This is my precise question. I'm asking the question to myself.
You are the licensee of the mortgagor.
I am in possession.
You don't have an independent right at all. Whatever the licensee had, licensor had, you have similar rights.
I am going to that extent that I'm in possession. A settled possession. But today, if I am a trespasser there, my lord, mortgage, I enter into the process.
That will be too high a proposition.
This I'm giving example to
no, even license or licensee, it's too high a proposition.
An example.
Valid license is a constant refrain in all these judgments.
The language of these judgments are, or the ratio of these judgments are, a person in possession pre-mortgage should not be touched.
That is not the ratio.
Madam, may I read with your lordship?
All valid license, all the judgments.
That is not the stage to decide.
Show me one judgment of the Supreme Court where this benefit was given to a licensee. One judgment.
I know, but whether I am a licensee, valid licensee, no licensee, that has required an adjudication. If today it is declared I am a licensee,
even if your suit is decreed, then also you are not entitled to protection. If your suit is decreed, you will be declared to be a licensee. How does it help you? You are construing your suit to be decreed from here.
Licensee is to be evicted. can the landlord and say and come
Subject
go?
to the superior rights of the mortgager, and
Today,
whatever the mortgager is subject to, you have the same jeopardy.
jeopardy, I can see the same right of the bank also. Today, my lord, my landlord can come and say, you go out, can say, even if licensee.
They have been evicted in due process of law.
There
13.
is no due process of law.
Had a
vis-a-vis
remedy
me.
under
Vis-a-vis me, there is no due process.
civil suit is not the remedy. We'll consider Rajasthan, we'll try to bypass it somehow.
My lord, I can only demonstrate before your lordship that I am in possession, which is pre-mortgage.
Yes, since we are against you, anything else? Don't cite judgment, all judgments say valid tenancy.
Let me check up the
No,
way my lord is observing today.
No, no.
Licensing.
He will check up before the Supreme Court.
এখানে আর কিছু নেই।
কিছু নেই। The present appeal has been
record by submission that the suit is not challenged and suit
Suit
is
is?
not challenged by them. The plaint rejected, not filed. They are contesting the suit. That are yes, they are contesting the suit today. Applied before this court for expedite disposal of the suit, and the bank was know of the fact that I was in possession.
The present appeal has been preferred against an order whereby,
May I have my last question?
please, an injunction application filed by the present appellant has been dismissed, and a petition under Order 39, Rule 4 of the Code of Civil Procedure for vacating the ad interim injunction granted on such injunction application initially has been allowed. Push up next panel. Learned senior counsel appearing for the appellant submits that, taking advantage of the predicament of the appellant, that this court initially did not have determination to take up Order 41 Rule 11 matters, and the appellant had moved before a different bench, comma, the bank has in the meantime taken possession of the premises, thereby ousting the appellant. However, comma, it is pointed out that the appellant still has a remedy akin to Section 144 of the Code of Civil Procedure to get restoration of possession since illegally ousted. Next para. Learned senior counsel for the appellant submits that the appellant has filed a suit for declaration of irrevocable license of the appellant in respect of the disputed property. The respondent bank has all along participated in such suit and has never filed any application for rejection of plaint or in the nature of demurrer. Next para. Rather, comma, the respondent bank has sought expeditious disposal of the suit from a different bench of this court. Next para. Despite having participated in the suit, comma, it is contended that it does not lie in the mouth of the bank that it could take possession of the premises under the provisions of the Surfacey Act. Next para. Learned senior counsel appearing for the appellant places reliance and stress on the fact that the appellant is a pre-mortgage occupant of the disputed property. It is an admitted position that the appellant had been in possession of the premises as a licensee under the owner, comma, the latter having mortgaged the property to the bank. Next para. Learned senior counsel takes the court through an annexure at page 134 of the connected stay application, which is a letter dated February 21, 2007, issued by the mortgagor to the petitioner, to the bank, admitting that a portion of the property which was mortgaged was under tenancy occupation on monthly rent. Thus, comma, a higher right of the appellant as tenant has been admitted by the mortgagor himself, which was well within the knowledge of the bank. Next para. Learned senior counsel also places reliance on a document in the nature of a certificate dated February 6, 2007, annexed at page 57 of the present application, where the mortgagor stroke licensor certified that it has allotted 340 square feet floor space within bracket the disputed property on the third floor to the present appellant for their day-to-day work free of cost. Full stop. Next para. In view of such admission of pre-mortgage possession of the appellant, comma, it is contended that the civil suit filed by the appellant is very much maintainable. Full stop. Next para. It is further argued that the appellant has not sought interdiction with any measures taken under the Surfacey Act against the mortgagor, but seeks to protect its own possession in the capacity of licensee in its own right with respect of the property. Full stop. It is contended that even a licensor or for that even a licensee, comma, or for that matter a trespasser, comma, is entitled to the protection of law inasmuch as such licensee stroke trespasser cannot be evicted without due process of law. Full stop. Next para. Learned senior counsel places much reliance on নামটা দিয়ে দেবে Bank of Rajasthan versus Sajid, reported at 2023. Thank you. 1 SCC page 1 for the proposition that the jurisdiction of a civil court to try a suit filed even by a borrower against a bank or financial institution is not ousted by virtue of the scheme of the then Recovery of Debts and Bankruptcy Act 1993. Full stop. Next para. Borrowing the same logic, comma, it is argued, comma, the fetter incorporated in the Surfacey Act to a civil suit does not debar the jurisdiction of a civil court to entertain a suit for declaration. Full stop. In the present case, comma, the appellant has filed a suit for declaration of its licensee rights, and as a consequential relief, comma, has sought injunction. Full stop. Thus, comma, such suit and the relief are very much maintainable. Full stop. Next para. Learned senior counsel next cites such and such reported at 2019 9 SCC 94, where it was held by the Supreme Court that if there is a pre-existing tenancy under the law created prior to the creation of the mortgage, comma, such possession cannot be disturbed by the secured creditor by taking possession of the property. Full stop. Next para. Since at the order 41 rule 11 stage, comma, the respondent does not have a right of hearing, comma, we choose not to go into the details of the contentions of the respondent. Full stop. Next para. However, comma, on a plain reading of the materials before the court and the impugned order, comma, we are of the opinion that no interference is called for the following reasons, colon. First, comma, the appellant cannot plead tenancy on the strength of the mere stray phrase in the mortgage document, in the letter of confirmation for creation of mortgage between the bank and the mortgagor, to the effect that a portion of the property is under tenancy occupation on monthly rent. Full stop. Not only does the said phrase not specifically refer to the appellant as the tenant or refer to the exact portion of the property which is under tenancy, comma, such statement is palpably contrary to the plaint case made out by the appellant itself. Full stop. The first relief sought in the plaint is a declaration that the plaintiff is an irrevocable licensee within the meaning of section 60 within bracket small b of the Indian Easement Act 1882. Full stop. Next para. In paragraph number 5 of the plaint, comma, the plaintiff stroke appellant company has boldly asserted that it was granted a license for running its business from the subject premises. First of next para, it is required to be noted here that the provisions of the Indian Easement Act 1882 are not applicable in the state of West Bengal. First of, although there are a line of decisions which say that the basic principles of equity and good conscience incorporated therein can be borrowed under general claims on tort, comma, the specific declaration of irrevocable licensee on the strength of section 60 within bracket small b of the said act cannot be prayed for prima facie in the state of West Bengal. First of thus, comma, the alleged irrevocability of the license cannot be sought within the state of West Bengal, comma, at least on a prima facie footing. First of next para, that apart, comma, the plaintiff has stated in paragraph 5 that it was granted a license merely for running its business from the subject premises. Pushed up to the present to the stay application in connection with the present appeal, comma, the appellant has also annexed a certificate of the mortgagor stroke licensee dated February 6, 2007, which is also important in the context. First up, the said certificate clearly says that the disputed plot was allotted to the plaintiff for their day-to-day work free of cost. Full stop. Whereas the expression double inverted free of cost indicates that it was a mere license, comma, the other expression within double inverted day-to-day work, double inverted close, clearly shows that exclusive possession was not imparted to the sorry appellant, but the license was in the nature of a day-to-day permissive occupation for the mere purpose of running a business. Full stop. Next para. Thus, comma, even on a prima facie view of the matter, comma, no exclusive tenancy rights were ever created in favor of the plaintiff, comma, nor has the plaintiff sought for such relief in the suit itself, from which the present injunction application emanates. Full stop. The ratio laid down in Bajarang Shamsundar Agarwal Supra, comma, cited by the appellant is not applicable at all to the present case, comma, since in the said case, comma, the Supreme Court was dealing with the interplay between the Transfer Property Act, comma, the rent control laws, as well as the Surfacey Act. Full stop. In such context, comma, it was observed by the Supreme Court that only if a valid tenancy under law is in existence prior to the creation of the mortgage, comma, the tenant apostrophe S possession cannot be disturbed by the secured creditor by taking possession of the property. Full stop. There is a gulf of difference between a valid tenancy under law and a mere license. Full stop. It is well settled that the possession of a licensee does not rob ROB the licensor stroke owner of exclusive possession or control of the property, comma, as opposed to a valid license created in law. Full stop. Next para. Seen from such perspective as well, comma, the proposition laid down in the said cited judgment is not applicable to the present case at all. Full stop. Next para. Insofar as Bank of Rajasthan Limited Supra is concerned, comma, the same was rendered in the context of the Recovery of Debts and Bankruptcy Act, comma, 1993, comma, which is a different statute than the Surfacey Act. Full stop. Although the restrictions imposed therein are somewhat similar to the Surfacey Act, comma, in view of the Surfacey Act, comma, as reflected in its object and reasons, comma, being specifically to expedite the recovery of debts from non-paying borrowers, comma, the provisions in the Surfacey Act has to be seen in a different context. Full stop. In terms of the Surfacey Act, comma, not only a suit cannot be entertained by the civil court if the same pertains to the powers conferred under the Surfacey Act, comma, the Surfacey Act specifically debars any injunction from being granted by a civil court in respect of such matters. Full stop. In the present case, comma, the respondent bank admittedly initiated measures under section 13 within bracket 4 of the Surfacey Act, and as such, comma, the jurisdiction of the civil court was palpably barred, comma, including the jurisdiction to grant any injunction. Full stop. Next para. That apart, comma, section 17 of the Surfacey Act clearly provides remedy to any person, including the borrower, comma, aggrieved by any measure so taken, comma, to take shelter of a legal proceeding before the concerned tribunal. Full stop. Thus, comma, on such count as well, comma, the plaintiff could not be said to be remediless in such situations. Full stop. Thus, comma, there is strong doubt as to whether the suit itself, comma, in the teeth of the measures taken under section 13 within bracket 4 of the Surfacey Act by the bank against the mortgagor stroke alleged licensor, comma, is maintainable at all. Full stop. Next para. In such view of the matter, comma, we are of the opinion that that although the impugned order is somewhat lacking in appropriate and elaborate reasons, comma, the learned trial judge, comma, nonetheless, comma, took into consideration the judgment cited before the said court as well as the arguments of the parties and claimed to a conclusion that this is a separate proceeding where the plaintiff by the suit cannot stop the proceedings under the Surfacey Act. Full stop. Hence, comma, we choose to supplement the somewhat unhappy language of the impugned order by further reasons as given above. Full stop. Since the conclusion of the learned trial judge was justified in law, comma, the reasons have to be read in the context of the further reasons which we have granted, which we have assigned in the present order. Full stop. Seen as a sum total of the said rationale, comma, we are of the opinion that there is no scope of interference with the impugned order. Full stop. Accordingly, FMAT 92 of 2024 is dismissed under Order 41, Rule 11 of the Code of Civil Procedure. Full stop. The connected applications bearing Can 1 of 2024 and Can 2 of 2025 stand accordingly dismissed as well. No orders to call.
Great.
My lords, may I please?
Yes.
My lord, before I trouble your lordships with the impugned order, my lord. My lord,
It
kindly
appears that I
permit-
am, my lord, not on caveat, my lord, but my lord, we came to learn of the appeal, and my lord, we are here today.
What is it?
Praying for dismissal in limine and courts in this appeal.
Lordship will do that. Lordship, after hearing me, lordships will dismiss.
No,
that.
what is the defect? Have you cured the defect?
Yes,
There-
my lord.
there's
Lordship,
some
the defects was with regard to the payment of court fees, my lord, which we have paid, my lord. Deficit court fees, my lord. It's uploaded as well, my lord. I believe, my lord, it was just short by 20 rupees court fees. Lordship sees the present status. Today only I have cured it, my lord. Last entry, my lord, at this page. Last entry.
Deficit court fees
have been paid, my lord.
Well, yeah.
So that has been rectified, my lord.
What is the matter about?
My lord, before I trouble your lordship with the impugned order, lordship will kindly bear with me and briefly permit me, my lord, to place the facts, my lord. Lord, my father, my lord, who was a successful businessman. Lord, his name was, my lord, Vishwanath Ganeriwal. Lord, he passed away, leaving behind a will, my lord. My lord, under the will, my lord, he, my lord, said that, my lord, all of his properties, barring 2 petrol pumps, my lord, will be transferred, will stand transferred to his the then Hindu undivided family, my lord, by the name of Vishwanath Ganeriwal IHF, my lord. My lord, the present appellant, my lord, is the eldest son. Lord, I am the eldest son. My lord, the respondent number 2, my lord, is my mother. My lord, respondent numbers 3 to 6 are my brothers, and 23 and 24 are my sisters, married sisters. Rest of them, my lord, are either my son or my nephew's nieces, my lord, and their family members, my lord. My lord, ever since the death of my father, my lord, the parties, my lord, from time to time have entered into various negotiations, entered into settlement. They have distributed their number of properties, my lord, allotted properties, and they have been enjoying there. My lord, way back in the year 2008, my lord, a deed of settlement cum partition was executed between the family members, my lord. By which, my lord, the parties, my lord, decided, my lord, which property will go to whom, divided, allocated, distributed. Signed by parties.
Unregistered?
No, my lord, that's where I am. Executed and given it to the registering authority, my lord, for its registration. But, my lord, that was kept pending for payment of deficit stamp duty, my lord, all this while. But each of the, my lord, the family members had been enjoying the allocations which were allotted to them under the deed, my lord, irrespective of other family members and without disturbance from any of the family members. What happens, my lord? In the meantime, in 2023, one of my brother, he files a suit before Alipur court.
For?
Seeking partition of the properties. Saying, my lord, that none of the properties have ever been partitioned, my lord. And he seeks partition of the properties of HUF, my lord.
Yes.
My lord, I enter appearance, my lord. I file an application under Order 7, Rule 11. I seek vacating or interim order as well, saying, my lord, there is a suppression of fact. There was a partition entered into between parties, my lord. Initially, the partition deed was kept pending. In the meantime, during subsistence of that suit, my lord, I paid 50 lakh rupees, my lord. I get the partition deed, my lord, completed registration, and my lord, I am trying to obtain original of the partition deed. But, my lord, one of my other brother, my lord, he was in possession of the original of IGR. Then, my lord, what they do, the plaintiff therein, my lord, he makes a complete U-turn. He says that, no, there was a partition deed, but it was given a go-by, and IGR has been destroyed. So, my lord, in that backdrop, my lord, since I was, my lord, since I was the one, my lord, who had made payment to the registering authority, my lord, I was trying to obtain original of the deed of partition, my lord. But, my lord, in as much as, my lord, I was not having original of the deed of partition, my lord, I couldn't. My lord, I approached this honorable court. In fact, lordships, sitting singly, lordships was pleased to hear that matter, my lord. If, my lord, if I may.
What was the order passed?
Lordships dismissed my, in fact, disposed of writ petition, saying that my remedy lied in filing a civil suit. Because, my lord, lordships held that since inasmuch as IGR was not issued in my name, so no fundamental right of mine was breached, lordships held that I can file a civil suit and take delivery of documents if I am otherwise entitled to in-law, my lord. Lord, while all these proceedings were going on, my lord, now, my lord, the respondent number one, who is the plaintiff in this suit, my lord, he files a suit, fresh suit, another suit, seeking declaration of that registered deed as void, saying that I was a major that time, but I am shown as minor in that deed of partition. Hence, that suit be declared void, and an injunction restraining me from obtaining original certificate, which, my lord, in my respectful submission, is in teeth of the order passed by this honorable court. He suppresses, my lord.
We don't have a right of hearing at the order 14. Sorry. Yes.
He suppresses those facts. My lord, be that as it may. Suit was filed, my lord, on 12th. Lordship will kindly note these dates, man. 12th of September 2024. Suit was filed. Title suit 1224. My lord, I come to know of the suit, my lord, on 14th of September. My lord, 17th of September, my lord, I try to apply for certified copy, my lord, in order to challenge that order.
What order was passed?
Injunction restraining me from relying on that deed, the deed of partition.
All right.
And the other consequential reliefs as well. I wanted to challenge that order, my lord. So, my lord, the matter was, while I was trying to apply for certified copy, the department told me that the file was lying before the learned judge. So, I was advised, my lord, that you better mention so that if the record is sent, my lord, we can. Lord, what I do, I approached the learned civil judge saying that I have applied for certified copy. At the then point of time, the plaintiff moves a section 151 petition before the learned, seeking correction of the earlier or 12th of September order. So, my lord, then I try to submit, my lord, that the order which has been passed, the plaintiff is in violation of proviso of Order 39, Rule 3, my lord, inasmuch as no copy of plaint or documents were submitted to me. The learned judge says, you take it here and now. You accept summons from the record, you take. My lord, I say, my lord, I have to take instructions. I cannot take it here and now. My lord, I say that and move. My lord, then thereafter an order is passed on that day. My lord, which my lord did not reflect the true events which had transpired on that particular day. My lord, I filed this application under section 151 before the court, saying that at least the record should be corrected to transpire as to what actually transpired, to record as to what actually transpired on that day. Now, the learned judge, what she does, by an order of 24 September, suit filed on 12th of September, by an order of 24 September, not only dismisses my petition under section 151, imposes a cost of rupees 20,000 on me, my lord, and makes the suit ex parte against me. All those orders were challenged before this honorable court. My lord, the appeal was taken up by hearing by my lord, the coordinate bench. My lord,
Revision?
yes. No, not revision.
Why appeal?
Appeal because initially, my lord, I had preferred appeal against the first order, and my lord, which kept on.
That was injunction, but this was section 151.
151. So, lordships, they have held. They say that there is no fetter in the appeal court. Though there is a civil revision which is also pending. My lord, I shall place that order as well. My lord, this honorable court, by an order of 8th of January 2025, my lord, recording the conduct of the judge. My lord grants me liberty to file my written objection to the injunction application filed by the respondent, gives me 10 days time, 4 days time to the plaintiff who is in the suit to file rejoinder, my lord, and directs the learned trial court to dispose of the matter within 10 days from completion of the pleadings, my lord.
Yes.
My lord, in compliance of that order, my lord, on 17th of January, my lord, I move a put-up petition, my lord, trying to file my written objection to the injunction application. Plaintiff appears, plaintiff submits, this is a suit for partition. A suit, I shall show from the plaintiff, says it's a suit for partition and holds that all the defendants should be served with the written objection. And my lord, the learned trial court, my lord, goes by whatever.
So what is the impugned order?
My lord, that my challenge is limited, my lord. As in so far as it directs me, my lord, to serve copy of the written objection, my written objection.
It is not appealable.
My lord, it is because it's an order that order has been passed under order 39 rule 1-2 application. There's no separate application. It's an
This order is not under order 39 rule 1.
Yes, yes.
In connection with an order 39 rule 1 and 2 rule 1 and 2 application, orders may be passed under other provisions also.
But there is no other provisions. Lordship
is not maintainable.
Lordship will kindly see the two orders I'll place. Thereafter, Lordship will decide.
The order directing you to serve copies on all.
Yes, my lord.
This is absolutely required.
My lord.
Only three.
Whatever.
My lord will kindly take my lord my second volume once, my lord. No. Order passed by this honorable court in appeal, my lord. Lordship will kindly take this. Thereafter, my lord,
this is not an appealable order. You go before the revisional court.
My lord, subject to correction, my lord, because this is an order passed on an application under order 39 rule 1 and 2. There is no, my lord, I did not file any petition. There is no petition filed by me. Lordship will kindly see the order passed by this honorable court.
Let us see the language of order 43 rule 1 R. An order under rule 1, 2, 2A, 4 and 10.
My lord.
Now let us come to those provisions, 39 rule 1, 2, 4, etc. One and 2 are grant of injunctions.
My lord.
2A is orders relating to disobedience. 4 is vacating.
My lord, four, I'm not on 4. My lord,
no, these are the 4 applicable or 10.
Yes, ma'am.
Now, 1 and 2, this is not an order under 1 and 2. Rule 1 and 2 says injunction can be granted. An order under that provision means either injunction granted or refused. Not any general order, any and every order is not a case decided.
Lordship will kindly allow me to place 2 orders.
You have directed to serve copies of the written objection.
My lord,
file a revision.
My lord, my respectful submission, my lord, that is in teeth of the order passed by this honorable. Lordship will kindly see
that.
that.
If that be so, but you do 227 lies. Revision, appeal is not made.
Maybe. My lord, Lordship will kindly hear me out for 2 more minutes. My lord will kindly permit me to place the orders, my lord. Thereafter, Lordship will decide, my lord. My lord will kindly take the second volume, my lord.
Second volume, yes.
Second volume. Page 298, my lord. Lordship will kindly permit me.
298.
298,
298, right.
Now, this is the order which was passed by this coordinate bench of this honorable court.
Right.
Lordship will, because, my lord, the conduct, sorry, Lordship will kindly pardon me, my lord, for using the term. My lord, the conduct of the judge is to be seen, the learned judge, my lord.
Which court is this?
Lordship will kindly see the memo of appeal, my lord, I have named. Lord, second civil judge, senior division at Alipur, my lord. Lordship will kindly see this order, my lord. Lordship will kindly. We are astonished to find that the defense of a defendant number 2 appellant is struck off within fortnight from the date of institution of the suit, as the conduct of the defendant number 2 appellant does not find palatable to the learned judge. It is an ardent duty of the judicial officer to conduct the case on the basis of the merit and should not be swayed by an extraneous factor and pass an order more particularly striking out defense, which is a valuable right. Order 8, Rule 1 of the Code of Civil Procedure provides 30 days period from the date of service of summons for presentation of written statement and the proviso inserted thereto, bestowed power upon the court to extend the said period of recording the reasons thereof. The right to file written statement within the statutory period is an invaluable right which cannot be squeezed or be shortened as the judicial officer thinks it fit to do so. The moment the legislature has fixed a timeline within which the defense is to be presented by the defendant, it cannot be struck off within the said period despite the conduct of the defendant does not appear to be proper. Striking out the defense within the period under Order 8, Rule 1 of the Code of Civil Code offends the core value of the right to defend and provide an easy path to the plaintiff to march over the same and get an ex parte decree against the defendant. It is an ardent duty of the learned judge to see that the justice is not only to be done, but seem to be done. Any order which takes away the valuable right of the defendant to defend within the period provided in the statute causes greater injustice, rather pretending the justice to have been imparted. Though the said order is not the subject matter, my lord, lordships, as lordships, my lord, said my lord, possibly that order could, their lordships, my lord, clarified that. Though that the said order is not the subject matter of challenge before us, but there is no fetter on the part of the appellate court to interfere whenever the injustice is manifestly evident. My lord, I would borrow passage from this lordship and try to impress upon your lordship, my lord. Manifestly evident and keeping in mind the core value of the constitutional ethos that a person cannot be condemned without being heard, we permit the defendant number 2 appellant to file written
That
statement.
injustice, Mr. Jain, was much more manifest. That your defense is struck out at this stage just because you did not obey the court or irked the court, that is manifestly unjust. That injustice can be cured under any provision. This is not so manifestly unjust that an appellate court where an appeal does not lie will interfere and ask you, no, don't serve copies on this.
My lord, under what lordship?
Then come back. Why, instead of wasting your time on the appeal?
Lordship, I pose
They
a
are
question
probably
to myself.
appearing also for those.
My lord, they are defendants. My lord, lordship will kindly. This will only open a new. My lord, and a petition filed by a plaintiff. My lord, if
The parties who have been directed to be served, they are appearing now. All of them are represented.
My lord, I am for the respondent number 1. There is no specific direction on any party. It is expected. I'll indicate. I'll take 30 seconds.
No, don't take 30 seconds.
My lordship will kindly permit me to place this order.
Yes, but it is appealable.
Kindly record my submission. This is to delay. This is to prevent the court.
Can't record anybody's submission in order for 10 rule 11. We have to dismiss it under order for 10 rule 11 or admit it and then hear it.
Then my lord will kindly just let me permit me to place the impugned order. Thereafter, my lordship will. Then, my lord,
not at all appealable, Mr. Jain.
My lord will kindly just.
This is not appealable.
My lord, I bow down to your lordship. My lord, I am absolutely lordships. My lord, add idea, my lord, if lordships permit me, my lord.
There's
yes,
no discrimination.
But my lord, lordship will kindly see the.
This is not a partition suit at all, in fact.
My lord.
No, it's palpable.
My lord, lordship will kindly see how the learned judge is conducting the suit, my lord.
The same judge.
Same judge, my lord. That suit is also.
You know your remedy, Mr. Jain. I did not advise you.
My lord, I know, but my lord, today.
Your remedy, take recourse to that remedy.
My lord, why I had to come before lordship?
You have sufficient apprehension.
My lord, I know.
The declaratory suit is treated to be a partition suit.
I filed section 24. That was dismissed because of pendency of that suit. Because of pendency of the appeal. My lord,
Which appeal? This appeal?
The appeal, the order which I placed just now on the same day. In fact, the honorable division.
Further remedy against that.
My lord, I do have. My lord, I do have. My lord, I am not on that. My lord,
take that recourse.
My lord, I shall. My lord, I shall try to take whatever recourse is available to me. But my lord will kindly see how this learned judge is dealing with these matters, my lord.
My lord, the learned judge is not here. I'll just put in one word.
My lord, in fact, this was an observation by the honorable division bench. Their lordship said that their lordships will call the learned judge.
Very well. I have not heard that line.
My lord,
nonetheless,
my lord, I was there, my lord.
Since I was there before the learned judge, and I'll give my lord what my honest view was. She was a very young judge. There was an application which made personal allegations against her. What the order was passed, that was a bad order.
No, for that she will treat a declarated suit to be a
No,
partition
that order
suit.
is bad. But I
This
think
order, that order was bad. You can appreciate. Here she has held that this is a partition suit and all requires to be served.
It's
this is not a partition suit.
Yes,
Here all
precisely.
this is here all the.
She holds in the partition suit as there is no discrimination between status of plaintiff and defendant.
No, this is a wrong recording.
So this order, why should this stand?
This is not appealable.
Since you are so keen to be heard, why should this stand?
This is not appealable order.
We'll treat this to be one under order 13.1 and 2 and then pass and
Then,
set it aside.
I'll-
We will hear you also. Yes, what is your
I'll try
contention?
to then convince me that this is not an order under.
What is your contention?
Milord, I am.
Why should all be served?
No, I am respondent number 18. Defendant number 18 before the court below. I'll tell your lordship, Milord. The agreement, the partnership deed which is under challenge, proposed to partition a part.
That is on the facts. This is not a partition suit. She has held this is a partition.
No, and all the parties, all the alleged parties to the deed
So
have
what?
been pleaded as defendants.
So maybe
I'll just.
but this does not become a partition suit by
No, this is not a partition suit. Milord. I'll just.
the suit for declaration of a particular deed to be bad.
Certainly not. But assuming that the recording, let's say the recording would have been correct. Had
Recording is the reason.
Had the learned judge recorded this, that this is a deed and these are all parties to the deed, and they all.
Had she recorded, don't speak for the, you need not speak for a judge.
But it's innocuous.
You don't have any business to speak for a judge.
No, I'm not.
And we cannot read the mind of the judge. If your client can read the mind of the judge, we have further apprehension. Why shouldn't we exercise jurisdiction under section 24? We can do that as a division bench. Why not use our latest patent jurisdiction and take the suit away from that judge? Partition suit. You are so keen to defend her.
No, my lord. It's a wrong record.
This should go in a service book.
It's a wrong record.
This should go in a service book. Our lineage does not mean that she has done the right thing. This is palpable vendetta against them. She treats it to be a partition suit, and there is no discrimination between the status of plaintiff and defendant, and everyone's interest in the joint property is same. So serve on all, just because the High Court order was placed before her. It's very palpable. The first paragraph records that the High Court order is placed, and then she says this.
That's completely wrong.
Caustic remarks should go be against her. Doesn't she see the records even? This is the partition suit. This is not a partition suit.
Not a partition.
Even if all the parties were the same. So, they have been permitted by the division bench, by a different division bench, to file a written objection. She asks them to file copies of all, on all. As the defendants are all co-sharers of the suit property and all.
Well, let me just please.
How can she even find this? Come to this finding that they are all co-sharers? Because there is a registered partition deed which is challenged. She is prejudging the suit. How can all of them be co-sharers if there is an existing registered deed of partition which is challenging the suit? That is the subject matter of the suit. She judges the suit itself at this stage. Do you realize?
No, well, I think I just.
One of the brothers. It's possibly because of the expenses which needs to be incurred for making copies and all.
No, not that. Why should they serve at all?
Parties. Otherwise,
Maybe. He is filing a written objection to a particular application filed by one party. Why should he serve on the all?
I just convey this that I'm agreeable to bear the cost if he agrees.
No, it's not a question of cost. It's a matter of principle. Why should he serve? And why should that be a deterrent for him? What was done ultimately? Let us see. Is directed to supply the copy of written objection. And you are suffering that injunction still now. But we cannot interfere in appeal.
Lord,
despite what you feel about the judge.
My lord, lordship will kindly direct me, my lord, that I am not. Lordship will kindly clarify this part, that I am not required to oblige to serve other defendants.
No. Why should he clarify? The present challenge has been filed against an order whereby the present appellant, a defendant in a suit for declaration challenging a registered deed of partition, was directed to serve copies of the written objection filed by him to the injunction application on defendant numbers 20, 21 and 22. Footstep learned counsel for the appellant argues that since the learned trial judge proceeded on a fundamental misconception that the suit is one for partition, whereas the suit has been filed for a declaration challenging a registered partition deed, comma, the entire premise of the order is bad in law. It is further argued that since the written objection was filed to an application for injunction filed by the plaintiff, comma, the present defendant stroke appellant is not under any obligation to serve copies thereof on the other defendants. Next para, learned counsel also refers to a checkered history of the matter. A partition suit was filed previously where the present defendant appellant took a defense that there was a previous, comma, though till then unregistered, comma, deed of family settlement whereby all the parties were allocated their respective shares, comma, which was acted upon. During pendency of such suit, comma, the previous deed was registered. Such registration prompted the filing of the current suit challenging the same. Next para, it is learned counsel for the appellant places reliance on a judgment of a coordinate bench passed in connection with a previous order of the same learned trial judge, whereby she had directed the defense of the present appellant to be struck off. Next para, in the said order, comma, the division bench had apparently made certain caustic remarks and had interfered with the said order even in connection with an appeal. Next para, although learned counsel for the appearing respondents seek to make their submissions, comma, we refuse such opportunity to the respondents in view of the respondents having no right of hearing at the stage of admission hearing under Order 41 Rule 11 of the Code of Civil Procedure. Next para, be that as it may, comma, we find from the order that although the same was filed in connection with an injunction application, comma, while hearing the same, comma, the order itself is not one passed under Order 39, Rule 1 or Rule 2 of the Code of Civil Procedure, comma, which are appealable under Order 43, Rule 1 within bracket small r of the Code. Next para, accordingly, comma, the remedy of the appellant, comma, if any, comma, lies by way of an appropriate challenge and not an appeal, comma, since the order is not appealable in law. Accordingly, FMAT number such and such, FMAT number 29 of 2025 is dismissed as not maintainable with liberty to the appellant to approach with a proper remedy before the appropriate bench. The connected applications are also disposed of accordingly. It is made clear, comma, however, comma, that the merits of the contentions of either of the parties have not been gone into by this court at all. Thank you.
May I have the liberty of taking back the
Certified
original
copy.
certified
Yes,
copy?
Appellate Adkoda. The learned advocate on record for the appellant is granted liberty to take back the certified copy of the impugned order annexed to the memorandum of appeal upon furnishing a photocopy thereof.
My lord, I have just now handed over a photocopy. Xerox photocopy I have handed.
হ্যাঁ তাহলে ওনাকে খুলে নিতে দিয়ে ওটা do it from the department. এটা ডিপার্টমেন্টে পাঠিয়ে do it, that will be more formal. Immediately এটা হ্যাঁ অর্ডারটা হয়ে গেলে immediately department by the end of the day we'll try to send it back to
deep
and then they'll have a right of hearing. There'll be no order for keep that in your mind also.
No, that
caveat has already been lodged probably.
Yes, only subject to caveat.
The people who are appearing, they are very diligent and caveat must have been lodged by him.
By now it must have been. That's grateful, Lordship.
Grateful, my lord. Yes.
My lord.
Yes.
My substitution application has been dismissed.
Order 21 rules.
Under Order 22, Rule 10. What happened?
Why dismissed?
My lord, I was a little surprised. I asked, how could a substitution be dismissed? What happened, my lord? Lordship knows in these multi-story buildings,
yes,
one books the flat, then gradually goes on paying. When the payment is full made, the promoter hands over possession. So one of such flat was taken by one Pukraj Sethi, and he inducted one tenant. Now, the eviction suit went on and decree was passed, and
Eviction suit by whom?
by Pukraj City against that tenant, the allotee against the tenant, and then an appeal was preferred. In appeal, they failed to deposit the rent, so
Stay order got vacated.
yes, defense was struck off and it was directed to proceed with the execution. At that stage, my lord, Pukraj City sold his flat.
Pukraj was the tenant.
Was the
allotee, sorry.
allotee. He sold his
to you
flat to me. Now the system is he gives an assignment. There's a third party tripartite agreement between promoter, new buyer, and the old buyer, and then the promoter executes the conveyance in favor of the new buyer. Now here the promoter has executed the conveyance in favor of my client. Registered, yes.
So,
but the
want to be implemented where? At what stage?
Execution stage, man. And they have also that somebody third party tenant has set up a third party order 21
97 99 to 100.
in that
So
case,
you want to get implemented in the shoes of Pukraj
lordship
as the
new owner, new owner.
Why was it refused?
Lordship.
Yes.
And I must point out that deed of assignment was not before the court below. We have made an application order 41, rule 27, bringing on record that deed of assignment by Pukraj City to
but
me.
is an appeal maintainable? This is not under order 20 rule 10 applies to
I
suit.
found from order 43 is F.
Order is not under order for 22 rule 10 because order 20 rule 10 applies to suits.
And this is also
This is an execution.
This also be treated as suit, my lord.
because of all the it's a miscase.
No,
It's a
no.
Miscase. It is treated as suit.
Miscase is not treated as a suit. It remains a miscase.
Lordship.
Remains a miscase, but the order by virtue of rule 103, it's deemed to be a decree for all practical, but it remains an order, does not become a decree. Unlike a rejection of plaint.
Okay.
Rejection of plaint is under section 2.
Yes, yes.
This is remains an order.
Huh.
The effect will be, the incidents will be that of a decree, and the provisions of appeal akin to a decree shall apply to this order, but it remains an order. Order 22 rule 10, let us just check up order 40, order 22 rule 10 is in respect of a suit, definitely.
Of course.
And this, let us once check up 141 also, section 141.
141.
That is not, that is different.
141 is not.
141 is proceeded for it, shall be fully as well in all proceedings of penal court. That is one. 126.
Order 22 rule 10 তো সুটে হয় 120 যেরকম অর্ডার 39 রুল যদি এক্সিকিউশন কেসে ইনজাংশন দেয় সেটা অর্ডার 39 রুল 1 তে হবে সেটা 151 এর ট্রিট হবে
141. These parts, my lord, will know better than
no
my lord.
definitely not definitely not at all.
I just checked the order 43 and these are deemed to be suit. So I thought, my lord, order 43 देखिए.
Tappings of a suit may apply, but it is not made a suit. And even if it has the trappings of a suit, by dint of that, we cannot have a secondary interpretation of order 20 rule 10 by implying execution case into suit. And order 21, you are right, order 21, that because order 21, please come to rule 103 once. 103 is the relevant provision. Where any application has been, it remains an application. The language is very clear. 103 says where any application has been adjudicated upon under rule 98 or 100, the order made thereon shall have the same force and be subject to the same conditions as to an appeal or otherwise as it were a decree. So much complication was not necessary if it was made a decree. Then it would be put under section 2.
May consider a comeback.
Appeal is not maintainable 100%. we cannot nowadays conversion is difficult because we'll give you liberty to file immediately a revision. You just copy paste the pleadings in the stay application and add 2 lines and you will get the revision. Mr. Gupta will do that by tonight. We'll give our reasons.
Well,
the present challenge has been preferred against an order whereby an application by the present appellant in the nature of one under Order 22 Rule 10 of the Code of Civil Procedure was dismissed by the executing court. Full stop. Next para, we find from a perusal of Order 22 Rule 10 that the same is applicable only in respect of a suit. Full stop. Although Order 21 Rule 103 of the Code provides that where an application has been adjudicated under Rule 9 or Rule 100 of the said order, the order made thereon shall have the same force and be subject to the same conditions as to an appeal, or otherwise as if it were a decree, comma, fact remains that by virtue of the said provision, comma, an order 21 Rule 99 to 101 application and or an execution case has not been intended to be converted to a suit for Order 22 Rule 10 to apply thereto. Full stop. Hence, comma, since Order 43 confers appellate jurisdiction on us only in respect of orders passed under Order 22 Rule 10, comma, the present impugned order is not appealable. Full stop. As such, comma, FMAT 05 of 2025 is dismissed as not maintainable, comma, since the impugned order is not appealable, comma, with liberty to the appellant to approach the appropriate court stroke forum with the for the same reliefs as sought herein. Full stop. Can 1 of 2025 is accordingly disposed of as well. Full stop. It is made clear that the merits of the matter have not been gone into by this court at all. Full stop. Next para. Liberty is given to the learned advocate on record for the appellant to take back the certified copy of the impugned order upon furnishing photocopy thereof from the department. This order will also be sent immediately to as soon as we sign the order.
Deeply.
Thank you. তাহলে এফএমএ যেটা বললাম ওটা এফএমএ নাম্বার পড়ে এফএমএ যা আছে থ্যাংক ইউ এফএমএ নাম্বার পড়ে গেছে
Number 25.
Yes.
In this matter, my lord, before my lord going into the impugned order, my lord, short facts is required to be considered.
Mr. Doctor, the defect has been cured.
Yes.
Good. Yes. What is the short fact?
Short facts, my lord. Initially, my lord, the father had. Short fact, my lord, the.
Mr. Doctor, first tell us what is the impugned order. Just tell us
impugned order, my lord.
Under which provision?
I filed application for custody before the Learned District Judge Barashat.
Give us the facts.
Order 7, Rule 10 filed by them, and my visitation application was filed. I got directed that both applications may be taken up, and both application was taken up for hearing.
Order 7, Rule 10.
Order 7, they filed.
On what ground?
The court has no jurisdiction. The plaintiff to be returned.
Why not? Family court.
Barashat court.
No, because family court is there, or what is? Why not maintainable?
Maintainable, that ordinary place of residence, not the Section 9. Under Section 9 of the Guardian and Wards Act.
Right.
Then, my lord.
The Guardians and Wards Act. No, it was brought on the last occasion. Yes. Now we are armed with many of the books.
Then, my lord, there was the direction of the my lord, that court, my lord, Barashat Judge's court. Then, my lord, I have taken back the plaint, and there is the plea taken by them that City Civil Court has got the jurisdiction in their application. And I have taken the plaint, and after returning within the time, I filed.
Yes.
The court entertained. Number given. And there I filed an application for visitation along with temporary and interim custody. The application was fixed for hearing. On that date, they filed application that Order 7, Rule 11. that court has no jurisdiction, the family court has got the jurisdiction. The court deciding the issues, I cited the judgment as passed by your lordship, and after considering that judgment, court held that family court has got the jurisdiction. That is the only, and application main custody matter has been dismissed, which is not permissible under the City Civil Code Act. My lord, your lordship kindly City Civil Code Act.
Order 7 by the impugned order, order 7 rule 11 was allowed.
Was allowed, plain dismissed.
So that's why you have preferred an appeal.
Preferred appeal. Your lordship kindly consider City Civil Code Act section 14. Section 14 of the City Civil Code Act.
Latest. This is the latest version we have. We don't know whether, I mean, there are many changes.
I have another book, my lord, City Civil Code Act, my lord.
One shall written?
My lord, this is, my lord. Section 14. The return of plaint for want of jurisdiction and provisions for crediting fees already paid. But this section clearly speaks about that court has no jurisdiction to reject the plaint. City Civil Court may return the plaint. Appropriate forum. And Order 7 Rule 10 also akin to Order 7 Rule 10.
Yes, yes.
And my lord, this is the prima facie, the order is not sustainable in the eye of law. And my visitation father is not getting access to the since 2021. We filed application. Visitation application, this application also not fixed for hearing that on the date of hearing of the visitation application, they filed application that was taken up, and without giving any chance to file objection, everything has my plaint has been dismissed. My submission.
You are agreed twofold. One, that the acted case could not have been dismissed. Even if that is allowed, and if you hold that acted case could not have been dismissed, then also you say the plaint could also not have been returned. Why do you say that? Why do you say family court does not have jurisdiction?
Well, your lordship kindly consider the City Civil Code Act. Section 5. Then I shall place your lordship judgment.
Because family court probably has a non-obstante clause also.
Well, this also, my lord. Section 5, your lordship kindly consider.
5 is.
Well, Section 21, my lord, overriding effect. City Civil Code Act, Section 21. Overriding effect. Well, Section 21, you also kindly consider Section 21.
Yes, but this is regarding jurisdiction of the court. But
well,
family courts act
override other law, including latest patent. Section 21.
Right.
Power to decide issues regarding
Guardian under the Guardian of Works Act, my lord, also one City Civil Code Act of the West Bengal Amendment Act. Well, you also kindly consider the Guardian of Works Act.
Yes.
None. Well, this is the state amendment, my lord. Well, Section 4. Well, Section 4, subsection, well, Section 4 definition. Well, subsection 4. District court has meaning assigned to that expression in the Code of Civil Procedure and includes a high court in the exercise of its ordinary original civil jurisdiction. State amendment. In its application to the state of West Bengal, in clause 4, section 4 of High Court in the exercise of its ordinary civil jurisdiction, substitute as respect of the city of Calcutta as defined under City Civil Code Act 1953. The City Civil Courts established such and such.
But Section 7 of Family Courts Act says the subject to provisions other provisions, a family court shall exercise all jurisdiction.
But I am not,
exercisable by any district court under any law for the time being.
But I am
not only under the Bengal Agra Assam Act.
But I am not on the way to that which court will decide. My submission, I am father. I am not getting access. And your lordship kindly send anywhere. I will go there. But my visitation cannot be obstructed by this way. But in the Varshat court, I have been obstructed. They raise the questions. The City Civil Court got the jurisdiction. My application has been entertained with that court. It is not my fault, my lord.
Have they in writing stated that city civil code
Yes,
has
yes.
this? Where is
Well,
that? Show us. Although this is a legal bar, but let us see their conduct also.
Hmm.
You have annexed only your applications, not their objection.
No, no. Well, এটা খোলো, এটা বিপটা খোলো, বিপটা খোলো। মানে they have stated মানে পুরো দাম করে দাও। পেয়েছো? Customer routine. Customer routine আছে দেখো। মোটা পাঁচ।1 minute, my lord. My lord, this is my lord, their application, my lord. My lord, I am reading, my lord. The respondent number 1, mother, begs to submit before this learned court that court has no territorial jurisdiction to entertain the.
Where are you reading from?
My lord, this is my copy only. Your lordship kindly. My lord, your lordship kindly.
You have not annexed it.
My lord, this is the my lord, in the court of Barasat, my lord, they have used this application, my lord.
What have they stated?
My lord, just I am reading and handing him.
Need not hand over.
Begs to submit before this court that this learned court has no territorial jurisdiction to entertain the miscase because the instant miscase should be filed before the learned court and district judge in whose jurisdiction the minor resides shall be ordinarily. Further, it pertains to mention that minor shall be scenario ordinarily resides at 125B Akhoy Kumar Datta Saroni Bortala and territorial jurisdiction of the learned judge city civil court. Well, this is the first paragraph.
Please keep it. Yes.
This is first paragraph.
Now, show us the law, Mr. Datta.
Now you lost.
What is that judgment? Yes.
Now you lost. You can give judgment. These are the well, you also decided these issues. Single bench. And
single is not binding.
No, well,
it is civil logic.
You should decided by lordship with city civil court and the guardian and what's act.
And my singly I decided.
My another matter is pending before the court is hearing this matter.
Even then, single judge is not binding, but let us see
not binding,
what logic. What is the logic?
My lord, your lordship kindly consider.
Oh, Mr. Banerjee was there.
Yes, yes.
He's the architect of all the mischiefs.
My lord, your lordship find CO number.
Mr. Banerjee lost the matter or won the matter there? Won the matter. Then he should lose here.
My lord, 2028 of 2028, your lordship find the certified copy, photocopy of the certified copy. Ordering portion, your lordship find. My lord, page 2 of the ordering inner page. The learned advocate appearing on behalf of the petitioner places reliance on the second schedule of the City Civil Code Act 1953 and submits that the Guardian and Wards Act 1890 has been referred to therein. the schedule read in conjunction of section 531, 53 Roman I of the said Act of 1953. It is submitted confers jurisdiction of the Civil Court at Calcutta to take up the all matters under the Guardian and Wards Act. As to the limited jurisdiction of the family court concerning only persons of the minor, the learned advocate for the petitioner concedes the said proposition and submits that the petitioner is ready to withdraw the matter from the family court and prosecute the matter which the return to the civil court. The learned advocate appear on behalf of the opposite party and the other hand submits that the family court does not, my learned friend might have submitted, have no jurisdiction to hear the matter regarding the custody of the property and minor, and as such, the proceedings before the family court was not maintainable in view of the Civil Court Act, Calcutta, having only general power to take the matter under the Guardian and Wards Act. It is argued of the jurisdiction of the adjudicate matter relating to the persons of minor still vested in the family court only. A perusal respectively acts shows that there is no specific non-obstantive clause in the relevant section of the Family Court Act of 1894, whereas Section 21 of the City Civil Court Act specifically provides the said act shall have the notwithstanding any contrary to the law being timing, including particular jurisprudence overriding effect. You also decided. In view of the matter, since Section 5301 read with second schedule of the Civil Court Act 1953 specifically confers jurisdiction of the Civil Court at Calcutta to take up all matters under the Guardian and Wards Act, it is evident that the Civil Court Calcutta refused to exercise jurisdiction based at such and such. In view of the pair such and such, Civil Court at Calcutta, this is the total, but the trial court rejected on the ground.
No, Mr. Dotto, you're right. This decision was rendered in view of, because the jurisdiction of the family court has been enumerated in Section 7 explanation. Regarding custody, it has been categorically mentioned a suit or proceeding in relationship to the guardianship of the person or the custody of or access to any minor.
But I have seen
so it was that distinction was made that this is in respect of the person of the custody or access to minor.
Access to minor.
If that be so, family court has jurisdiction.
Right.
Then if it is regarding property, then automatically the default clause comes in, 5(3) comes in, because if there is no conflict, if it's regarding the property, there is no conflict with the Family Court Act.
But I am not, my lord.
Otherwise, 5(3) provides that the Guardians and Wards Act
I am not in
have
the
to be taken up by the civil
but
court.
I am not in the way of, my lord, whether the family court will take up the matter or the city will take up the matter.
But your suit is in relation to the guardianship of the person.
Permanent
or custody of or access. See, it's purely custody, not regarding property.
The court held that as
you have to go to the family court.
As there is a nomenclature under Hindu Minority and Guardianship Act, so
that was a wrong logic.
Wrong, that is the only nomenclature.
No, but
only one thing, my lord.
Why wrong logic? This application is under.
Under the, my lord, I have said that Guardian and Wards Act. Also said in my application.
In any event, either way, it has to go as per this judgment also, my judgment also. The distinction was made on in the light of the
my submission that cannot be dismissed.
No, that is always there.
But I am ready to go. Whatever lordship will pass order, we will face that. We shall go there. But my lord, my visitation, my lord, at least, my lord, you lordship kindly.
It was held in this judgment that jurisdiction to adjudicate matters relating to the person of a minor still vested with the family court.
Yes.
So very well, then go back to the family court. Mr. Banerjee, how could the suit?
In the meantime, my lord, the father maybe get access to the.
Dispose of the appeal. Mr. Banerjee, how could the acted case be dismissed? We'll set aside that and we'll relegate it to the family court.
Well, only one thing, my lord. In the meantime, when your lordship is that is the, my lord. Your lordship is
go before the family court day after tomorrow. Draft it tonight.
And in the family court there is the provision, my lord. First mediation, counselling. That will take more time. Your lordship kindly
dispose of the appeal. You are not in season of the matter, Mr. Dotto.
Family court act, my lord, says that first mediation, then counselling,
whatever,
then counselor here. Well, then, my lord, the advocate are not getting access to the family court. Well, there are so many factors. In the meantime, the father since 21 is fighting to see this to visit.
Your lordship kindly, for a few days after we dispose of the appeal, we cannot pass any such.
Your lordship kindly but kindly, for the present, my lord, stay that order for the time, admit this appeal. My lord, my lord, only one thing, my lord,
With
regarding,
his consent, dispose of the appeal.
my lord, regarding visitation, your lordship kindly.
Mr. Doctor, go to the appropriate court and ask for visitation.
My lord, I shall go there, my lord, but when your lordship kindly
Pass our order when you have finished.
No, your lordship, right, your lordship. I cannot say, but your lordship kindly consider the difficulty, my lord, the father is not getting access. That is that's why, my lord, I am praying your lordship that
we have failed to impress upon you the law. So if you are not on the law, then we won't hear you. You can go on arguing.
No.
You cannot go beyond the law.
I am the last person, my lord.
You are the first person who is doing it.
No,
throughout the day.
What your
the first person throughout the day who is going against the law.
No, what your lordship pass
I
order?
don't know of any logic which says that a court, when it disposes of the appeal, still is in and can pass an interim order of visitation. Go tomorrow, apply before the family court. In the mediation also, there are ample provisions, Mr.
Right, your lordship, right.
You can ask for custody in the interregnum.
Your lordship can do it.
Learned counsel for the Mr. Banerjee, we are recording your consent for disposing of the appeal itself. We'll set aside the dismissal, we'll relegate it to the family court.
But he has to file a fresh application before the.
No.
Yes.
Well, that is Civil Code Act says that
no, it can be transferred. Why
it is transferred.
Why not?
Under Civil Code Act.
We just transfer it. All the same, if you file a new application, no, Mr. Dutt, it will be quicker for you if you file a new application. If that is transferred, it will take time.
File application, then it will be registered, then someone needs to be issued again.
Do you seriously think that if it goes from the city court, the records go to the family court, it will be easier
if
for
you
you?
lost it direct,
if you are confident of that, we'll do that.
If you lost it direct, that
we direct regularly. Every day there are several directions passed for transfer.
I hope
or you choose your choice.
But I hope that your lawsuit directions must be complied with.
We also hope that regularly. Therefore, we have stopped taking up contempt applications, new contempt applications.
Family court has certain paraphernalia, my lord.
No, but the city civil court shall not have jurisdiction. Probably there is a provision for transfer.
Section 14. Well.
Section 14. Mr. Banerjee, you can come to section 14. They can return the plaint.
Yes, yes.
So whatever they can, we can also. I mean, because you are sitting in appeal. So we'll direct the return of that application and presentation to the. Not transfer, return and presentation.
Lordship is relying upon section 14 of the City Civil Code.
Yes.
But this Family Court Act will have an overriding effect on it.
Yes,
Lordship
definitely.
kindly passes order whatever way.
No, Mr. Banerjee, we are saying this because it is now before the City Civil Court.
Yes.
The City Civil Court is in season of the matter. City Civil Court.
Setting aside the order passed by the City Civil Court.
City Civil Court, we are setting aside only to the limited extent where it has been said that the acted case is dismissed.
Lordship.
But we are retaining the other portion of the order that it is not maintainable with the City Civil Court.
So
if that is held by the City Civil Court, the remedy for the way out for the City Civil Court is only under 14. City Civil Court does not have any other formula. Learned counsel for the appellant. The present appeal has been preferred against an order whereby the Act 8, Roman 8, case of the petitioner father for custody and interim visitation of his child has been dismissed altogether on the finding that the family court and not the City Civil Court, has jurisdiction to take up the matter. Full stop. Since there are arguable questions involved, we admit the appeal and with the consent of the parties, take up the appeal itself for hearing, particularly keeping in view the implicit urgency involved as the matter arises out of a custody proceeding. Full stop. Next para. The appellant challenges the order on the ground that in terms of an unreported judgment passed by learned single judge of this bench in CO number 2028 of 2018 with CO 2587 of 2018 with CO 407 of 2019, it was held that the City Civil Court, under section 5 within bracket 3 of the said of the City Civil Court Act, has jurisdiction to take up custody matters. Pushed up. Next para. It is argued that the learned trial judge misinterpreted the said decision. Full stop. It is further argued that in a previous proceeding for custody initiated with the same for the same relief before the Barasat court, the respondent mother had taken an objection on the ground that the City Civil Court and not the Barasat court has jurisdiction. full stop, thus, comma, the present demur taken by the respondent before the city civil court, comma, on the basis of which the impugned order was passed, comma, is mala fide. Full stop, it is further argued that the City Civil Court Act also has a non-obstante clause, and as such, comma, section 5 within bracket 3 prevails over any other statute. Full stop, next para. Learned counsel appearing for the respondent controverts such submissions and points out that in the unreported judgment cited by the learned advocate for the appellant, comma, the court had distinguished between an application for custody in respect of the property and the person of a minor. Full stop. In case of the former, comma, the city civil court might retain jurisdiction under section 5 within bracket 3, but in respect of the latter, comma, the family court has jurisdiction under the explanation to section 7 within bracket 1 of the Family Courts Act 1984. Full stop, next para. The appellant also argues that in any event, comma, the acted case itself could not have been dismissed by the learned trial judge, even if it was held that the family court has determination to hear the matter. Full stop, the appropriate course of action would have been to return the plaint under section 14 of the City Civil Courts Act. Full stop, next para. We find from a perusal of the unreported judgment of a learned single judge of this court cited by the appellant that, comma, as rightly pointed out by learned counsel for the respondent, comma, the same distinguished between an application for custody in respect of the person of a minor, comma, for which the family court was held to have jurisdiction, comma, and the property of a minor, which, comma, not coming under the purview of the explanation to section 7 within bracket 1 of the Family Courts Act 1984, comma, has to go before the City Civil Court. Full stop, next para. We also find from the concerned provisions that section 7 within bracket 1, comma, in its explanation, comma, clearly enumerates the suits and proceedings which are to be heard exclusively by the concerned family court. Full stop, in respect of such matters, comma, undoubtedly, comma, since the Family Courts Act is a special statute having overriding effect and having been enacted subsequent to the City Civil Courts Act, with the legislature having full knowledge of the existence of the City Civil Courts Act, comma, the jurisdiction of the district court is ousted in favor of the family court. Full stop. However, comma, clause small g within bracket of the explanation to section 7 within bracket 1 of the Family Courts Act provides that a suit or proceeding in relation to the guardianship of the person or the custody of, comma, or access to any minor has to be heard by the family court. Full stop, next para. To such limited extent, comma, the said provision overrides section 5 of the City Civil Courts Act. Full stop, although section 21 of the latter act lends overriding effect to the act over anything to the contrary in any other law, including in particular the latest patent of the High Court, comma, the Family Courts Act also provides in section 20 thereof that the provision of the said act shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force, or any instrument having effect by virtue of any law other than this act, other than the said act. Full stop, next para. As held above, comma, since the Family Courts Act was enacted at a time when the City Civil Act was already subsisting and came within the purview of, within double inverted, any other law for the time being in force, double inverted moddhe, as enumerated in section 20 of the Family Courts Act 1984, comma, in the event of a conflict between the two, comma, the Family Courts Act, comma, which is a special statute in respect of the disputes mentioned therein, comma, prevails over the City Civil Codes Act. Full stop. However, comma, although there is no conflict regarding the regarding an application for guardianship of a minor or in respect of the the guardianship in respect of the property of a minor, comma, the same would go to the City Civil Court, comma, insofar as an application for custody or access to the minor is concerned, comma, the same is squarely covered by clause small g of the explanation to section 7 within bracket 1 of the Family Courts Act 1984, and as such, comma, has to be heard by the Family Courts Act and not by the City Civil Court. Full stop. Accordingly, comma, the learned trial judge was justified to the extent that it came to the conclusion that the family court has jurisdiction to hear out the matter. Full stop. Although the reasoning that the application was not under the Guardians and Wards Act, but where is that finding?
And Hindu minority and
no, where is that finding?
Minority lordship.
Yes. Is there a clear finding to that? But under section 6 of the Hindu Minority and Guardianship Act 1956, comma, the same is a bit doubtful, comma, since quotation of captions is immaterial. Full stop. Be that as it may, comma, fact remains that the present application fact remains that the conclusion of the learned trial judge was correct to the extent that the application was maintainable before the family court. Full stop. Next para. However, comma, the learned trial judge erred in dismissing the Act 8 case as a whole. Full stop. The appropriate recourse for the City Civil Court, comma, under section 14 of the said Act was to return the Act 8 application to the petitioner stroke appellant for the purpose of being presented before the appropriate court, that is the family court having jurisdiction. Full stop. Accordingly, FMA 122 of 2025 is allowed in part, comma, thereby modifying the impugned order to the effect that the application filed under Act 8 by the appellant for custody and other reliefs relating to the minor child of the parties, comma, is hereby directed to be returned to the appellant for being presented before the appropriate family court having jurisdiction. Full stop. The City Civil Court shall act on a server copy of this order for the purpose of compliance and ensure that the application is returned to the appellant at the earliest after such communication is made. Full stop. Immediately thereafter, comma, the petitioner, that the appellant shall present the same before the appropriate family court. Full stop. It is expected that upon being so presented, comma, the family court shall consider the scope of granting any interim relief to the parties, comma, if permitted in law. Full stop. This court has not gone into the merits of the allegations and counter allegations of the parties, and it is left open to the concerned family court to deal with all issues independently and in accordance with law. Full stop. Can 1 of 2025 stands disposed of accordingly as well. No rest to cost.
But only one thing, one small prayer before lordship.
Yes, Mr. Datta.
If you lordship direct the family court to expedite the matter, my lord, the child is going to mature, my lord. He is 16 years, my lord.
We have already directed. We have passed out. We have said that not only that expedition at the earliest, but also in interim, if there is any scope of interim prayers, that will be considered. Correct. Thank you, sir.
We are deeply obliged here also.
Next.
My lord, very recently, that judgment has brought Supreme Court, my lord, in deciding the habeas corpus matter regarding family court, district court, everything has been decided. And judgment, my lord, so recent judgment, and that either district court or family court, civil court or family court, either of the court.
That has been held.
That has been held, and that's when the judgment, my lord, in deciding the matter, the court, my lord, passed an order arrangement for visitation and everything in deciding the matter, and that will continue till disposal of
That
the.
is under 142, Mr. Datta. Article 142. We don't have that power.
No, family court and civil court.
Why didn't you cite that judgment?
As your lordship decided this, I have no obligation that I will go either family court or anywhere. I only get my daughter to see.
After 2 years, she may go come to you also.
Right, but when the child is going to be, my lord, seat for the joint entrance in the medical. When it's 12 class, my lord.
We're happy for her.
Father is my she was under the custody of the father. Father was the teacher also, my lord. That is, the father is.
After 2 years, her mother does not have a say. She will have a
right.
choice.
But this is a crucial time, my lord. The training was his hard, my lord.
True.
That's why, my lord, father's eagerness, I submit to your lordship.
Absolutely. Yes, parted matter. What can we do in 10 minutes? Not even 8 minutes. Every day when you take up this matter, you can start the matter, Mr. Banerjee.
Lordship will fix it up at Lordship at certain time, Lordship, 12 p.m. or something.
Then the other matters will suffer. Order for two on application, your own application may also suffer. Applications and order for two matters are more urgent. At least we are including some appeals.
Yes.
Oh,
Grateful for that.
Yes, what is the matter about?
Kindly take some, at least volume 1 of that paper book.
All right. Yeah, volume. With this size and Mr. Banerjee with you on the other side, it's a daunting, it's very formidable for.
Short matter.
Voluminous, subject matter might be short.
Yes.
Lordship, I place that judgment.
What is the matter about this?
Yes. The appellant, Lordship, is the defendant in a suit for declaration, only declaration, whereby, Lordship, the plaintiff has claimed that they are 5/6 part owners of the shares and securities left by the predecessor in interest of both the appellants and the defendant.
No injunction also sought?
Yes, injunction sought.
Partition not sought?
Partition not sought.
Remember Mr. Rai's argument in the other matter? Against you?
Against me. Might be against me. No consequential relief.
Other and further?
Yes.
So that's another relief. And you won that matter on that ground?
On that particular. It was decided.
Any other ground
Yes. It was initially decided against them. After it was first appeal was preferred. Remanded back. Against that, I am before your lordships.
You are challenging the remand order.
Remand order.
Now you are challenging the remand order.
No, because it was remanded when
after remand,
decree was passed. That decree was passed. That decree has been challenged. On the last occasion, I placed that judgment.
What are the contours of your case? But just in a nutshell, I mean, what are your points?
This honorable court remanded it on a very limited ground. That was the learned trial court decided everything in a new fashion.
So the trial court traversed beyond the remand.
Beyond the scope of remand.
Remand order limited. Show us the remand order.
Yes.
You were showing us the remand order.
Yes, that starts at page 151.
Yes, right. 154 is the relevant portion.
154 it starts, my lord, the relevant.
Rather, it starts there. So Swarup Vikas was the focus, you said.
Yes.
No, actually starting it won't take us anywhere. And nothing will be done in 5 minutes.
This has to be gone into.
Yes, at least the order of the remand order has to be.
Two orders, remand order and the remand order and the next
remand order and the judgment of
and the impugned judgment.
Yes, Mr. Banerjee, should be short. Remand order and the scope of
impugned judgment.
You will have to take us beyond Swarup Vikas and.
After the remand order, Lord, they were directed to lead evidence in order to prove that the debts and securities in the name of the deceased.
They did not lead evidence.
They did not lead any evidence.
That is another
because Lord 1/6 here in respect of the dates mentioned in the plaint has been declared by this court while remand order was made.
That cannot be
But
reopened.
they argued before this court, Lord, before remand, that no, certain dates belonging to myself. Then court said, go there, adduce evidence, prove that. They did not adduce any evidence, prove that.
So even if that point is
Rather,
accepted, then otherwise.
Rather, we proved the document, that is the second volume, second
That
part.
is what they
These
said
are
is
the
beyond
exhibited
the.
documents.
Yes.
From which it appeared, Lord, they withdrawn from the shares of my in the name of the father, then they purchased it. And Lord, very deep, very Lord, it is clearly a case of a fraud. Because Lord, on consent, my Lord, succession certificate was obtained. That in respect of item number 1, 2, and 3, so far as that part is concerned, they are entitled. So far other part is concerned, Lord, we are jointly entitled. Lord, accordingly, my Lord, on consent, order was passed. After 20 years, my Lord, they came and filed an application for extended succession certificate. They got it without giving us notice.
I am not reopening
that
the
is
previous.
No,
that I cannot.
একটা order record করে নাও আজকে তার appearance record না করলে ঠিক হবে the heard learned counsel for the parties for further hearing tomorrow দুপক্ষের নামটা record
Lordship is fixing it at any time.
No.
It will come in the regular course.
Yes, please.
Before rising, may I be permitted to mention one matter, my lord? My lord, item number 21 has been fixed by your lordships tomorrow, my lord. My lord, kindly fix it either Friday or Tuesday.
At this point of time, we would not do that. But when it is taken up, please ask any of your learned junior friends to be present. If you are in difficulty, we'll consider. Just inform the other side only, so that they are not in difficulty.
I'll tell you no other side.
Then no difficulty. Keep somebody when the matter is called on.
Yes, I'll my junior.
Great.